Okay, good morning. We're here outside the presence of the jury, 214-2024 CR 0028, State of New Hampshire versus Dustin Duren.
Hey all, good
Counsel.
morning. Here we
Mr.
go.
Duren. And I know that after the close of business, I did circulate the jury instructions consistent, well, what I believe with my orders yesterday. And Attorney Kettles, looks like you have a question. Is it on that or on something else?
Yes, Your Honor. And maintaining all of the previous arguments we made yesterday, I just wanted to point out one additional note based on the draft that was circulated last night. Starting at the bottom of page 12, continuing on about halfway through page 13, the discussion about the distinction between deadly and non-deadly force, we would ask that that be stricken. I don't think there's any dispute in this case that the force used was deadly, and so I think it is confusing to the jury to have them be doing this weighing of deadly versus non-deadly force, especially in this coming after the second-degree murder knowing charge where deadly force is not one of the elements, caused the death of another is one of the elements.
Okay, and I note that in the defendant's submission, which I denied yesterday and is again colloquially known in these parts as the NOMAR instruction, that in the defendant's requested instruction, there was a definition of deadly force that was in the defendant's overall requested instructions. I would note that for the record.
Yes, Judge, and reading the current version of the instructions, I think that this series of paragraphs with what the current instructions are a little bit confusing. And so just seeking to have the clearest and most simple language possible for the jury based on the court's ruling yesterday.
Okay, understood. Anything further, Attorney Gross?
No, no.
Okay.
We disagree, Your Honor. We think these instructions are appropriate. They were contained in previous drafts as they are in this final draft. I don't think there's any reason to take them out. I don't believe it would be confusing for the jury to understand the difference between deadly force and non-deadly force in a situation where they're going to hear arguments after hearing testimony about someone who fired a gun at someone for allegedly hugging someone too tight. I think that's deadly force. That's not deadly force. It's important to know the difference.
Okay, all right.
And so, Judge, that sounds like the state wants this instruction not as it goes to Mr. Duren's use of force, which is the purpose, but to try to somehow bolster the actions of Ms. Naffziger, which is an improper purpose. If there's going to be an instruction on deadly force, it should be about the defendant's use of deadly versus non-deadly force. And the state just said that's not why they want it. They want it for a different and, I think, impermissible purpose.
I would disagree with counsel's characterization of the state's argument. I don't think there's anything else that the state needs to say.
Okay, all right. Anything further? Any party?
No, Your Honor.
Okay, all right. Defendant's request is noted. Defendant's request relative to that removal of that instruction is denied based upon the arguments contained by counsel, also based upon arguments as referenced yesterday during the charging conference, the lengthy charging conference, and also based upon the defendant's submission relative to jury instructions, which did include a requested definition relative to deadly force. I think that based upon the overall circumstances, the instructions adequately and reasonably set forth the issues for the jury to be decided with respect to this matter. So over the defendant's objection, that specific portion of the instructions will remain in as drafted, as prepared. Anything further, Attorney Kettles?
No, Your Honor.
Okay, Attorney Spicer, anything further?
No.
Okay. All right. Last bit of business, which I just want to make sure we want to make sure that during just relates to logistics. I want to be able to make sure that I've established that I can I think under the circumstances, the best thing is to go back where it was yesterday, and I will simply move down to that portion.
That's
that's going to take us at least 20 minutes, Your Honor, of taping wires and moving the equipment and resetting up another monitor.
No, when I said yesterday, I meant at the end of the day yesterday. I just meant shifting that to the,
Back to where it was.
this morning.
This is over here, over this way.
This morning. This morning.
I'm not, no, I'm not talking about,
Thank you. I thought you meant
No.
moving it all the way this way, Your Honor.
Yeah.
I apologize.
yeah, I think,
And if the court, Your Honor, if the court needs or requires it after we're done with closing and before, when the court is instructing, we can disconnect the cords and move the TV straight across the room.
yeah, no, I think under the circumstances, I think if I'm here, then I can maintain the most, it's a rather narrow angle. It's a narrow angle of being blocked, and I think I can see everything I need to be able to see for purposes of the record. If I position myself here, any objection from the state relative to anything?
No, Your Honor, we do appreciate it.
Okay, anything from defendant if I,
No, Your Honor, I just note that we now can't see that screen, so I'd just like to test, the state has said it
Yeah,
should still
this
work, but I'd
letter
like
is
to
still
test
working.
it before the jury comes in, since we now can't see that.
Please.
If you could just turn it on and make sure it's connected.
so I should ask Madam Clerk, do you object if I?
No.
Okay.
Is your monitor power on?
Yes.
It's on this.
It's working on the judge's bench. We're not seeing anything on your judge.
I think before you have the
Wiggle the wires. So we'll have to test before the jury can. HDMI no signal. Went from screen to no screen.
Oh, it's on, there we go.
Okay.
Attorney Kennels, are you
We can now see this, yes.
up and running? Okay. So once again, please let the record reflect that based upon the configuration of the courtroom, the court does find it to be in the interest of the jury and in the interest of those in attendance, as well as counsel. It appears that everybody has the ability to see the monitor. Judge, I will move down to a position directly behind the clerk's bench, from which vantage point, let the record reflect that I will be able to maintain visual contact with the jury as well as the parties in this case, and I've consulted with counsel as to that issue, and there's no objection, so I think we should be sufficient under the circumstances. If an issue does arise, of course, I reserve the right to momentarily pause the proceedings in order to bring some, whatever change is necessary under the circumstances. Anything further from the state before we line up the jury?
There you
No.
go. Thank you. No, you're on.
No, you're
This way? Okay, all right. Thank you.
Well, while they do that, because I accidentally pushed the go live button way too quick, I don't know what I was thinking. But thank you for joining me. Ooh, what is that? Thank you for joining me today for the
Thank you.
for the oh God, my brain just went phew.
Use the bathroom and then I
What
heard
the-
her collapse on the floor.
My TV keeps going off. Thank you for joining me today for the closing arguments in the Dustin Duren trial. I'm not sure how long it's going to take, but this is true crime for you and celebrity news. It's Tuesday, October 28th at 8:07 a.m. So thank you. And also please like, share, and subscribe. I will get it together. It's a little early. I took a lot of sleeping meds last night, so it's taken me a minute to get my brain together. All right, here we go.
Now, session, the Honorable Donald F. Brazell presiding.
Okay, good morning. Thank you. Please be seated. Okay, good morning, members of the jury. Thank you for your punctuality. Thank you for your service. As I told you yesterday, we're about to proceed with closing arguments from the defendant and from the state, and you'll also hear my instructions to you before you retire to the jury deliberation room to decide your verdict. The first matter, obviously, you can see in order to allow the presentation of certain items with respect on the screen, the screen has been moved over here. As a result of that, I'm stepping down here so that I can maintain visual contact with you folks as part of this proceeding. So I will do that during the closing arguments, and I've consulted with the lawyers, and they're in agreement with that. So I will be moving down here just so that I can continue to see what's happening. I can also see the screen from where I am here. So the first order of business, as I mentioned every morning, because there has been a media presence with respect to this trial, I again ask you if you have had any exposure to any of the media coverage, any information outside the confines of this courtroom, even if it was inadvertent. If you have received any such exposure, I would ask that you please raise your hand to indicate so, and we will address it at that time. Okay, please let the record reflect that none of the jurors raised their hands, so thank you again for following my instructions in that regard. And we are now at the point of closing arguments. And again, closing arguments, jury instructions, and then at that point you will, once I give you the permission, you will be able to talk about the case and the evidence at that time. Okay, so anything further, either counsel before closings? Okay, I will give you 1 second, Attorney Piles. I'll move down here. I've been offered the clerk's bench. I'll take the clerk's bench. That. Okay, thank you very much.
The law says that Dustin Duren is not guilty. The law says that Dustin was justified when he shot Caitlyn Naffziger. The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin Duren is not guilty. This is a case of secret plans, broken promises, and a father's unyielding love. It is about a Marine reacting to a threat toward his beloved daughter. A horrific tragedy, but not a criminal offense. The law says that Dustin Duren was justified when he shot Caitlyn Naffziger. Dustin Duren is not guilty. Caitlyn Naffziger went to Dustin's apartment in Berlin in late February 2024 under false pretenses. She told him that she was there to drop off his daughter Valen, but she was actually there with a secret plan that she came up with together with her Aunt Brenda, a secret plan to take both kids to Minnesota without Dustin knowing, a secret plan to kidnap the children. And it wasn't the first time that Caitlyn Naffziger had kidnapped one of their children. When the family lived in Las Vegas, Caitlyn walked out of the house with baby Valen in the stroller. She pretended she was going to the park. Hours later, she hadn't returned. Dustin went to the park to look for them, and they weren't there. Caitlyn had taken the baby not to the park, but to the airport. She was flying to Minnesota with their baby, moving out of the state with Dustin's child, without telling him. without getting his agreement, without even letting him say goodbye. Caitlyn had kidnapped Dustin's child before, and when she came to New Hampshire, she planned to do it again. Caitlyn and Brenda had a secret plan to kidnap the kids, to unlawfully interfere with Dustin's custodial rights, to take both Elwyn and Valen to Minnesota without even telling Dustin. But that secret plan was interrupted. Caitlyn had to change her plan once Dustin began to figure out that something wasn't right. And here's what happened. First, Brenda drops Caitlyn off at the restaurant rather than sticking around to take Caitlyn back to her place in Hampton. Then, Caitlyn wants to go back to Dustin's apartment in Berlin, where she had told him before she didn't want to stay. The next day, Caitlyn won't tell him when she is planning to leave. Caitlyn is acting suspiciously. She's ignoring him, doing something on her phone, refusing to engage about what is happening with their children and what she is planning to do. And this is the exact same thing that she did last time she kidnapped one of their children. And so Dustin is getting more and more suspicious. After Caitlyn ignores him all afternoon, Dustin decides that Caitlyn, who's refusing to communicate with him, is no longer welcome in his apartment. He tells her she needs to leave. She ignores him again. He tells Caitlyn it's time to leave and he will drive her back to Brenda's place. And to get ready to go, he puts Valen in the car seat near the kitchen. And when Dustin tells Caitlyn that she's no longer welcome at his place, Caitlyn's secret plan to kidnap the children is interrupted. Caitlyn realizes she is not going to be able to steal the kids away from Dustin without him knowing. And so Caitlyn changes her plan. She reacts. She grabs Elwyn to use her as leverage, to use her as a pawn to try to enact the plan. Dustin comes back into the living room and sees Caitlyn sitting on the couch, holding Elwyn from behind. Elwyn is straddled on Caitlyn's knee. Dustin tells Caitlyn, "Come on, we're leaving," and tries to grab Elwyn to get Elwyn ready to go. But Caitlyn refuses to let Elwyn go. She grabs Elwyn and she pulls her back. And Dustin lets go because he doesn't want to engage in a physical struggle with Caitlyn over their child. So he again asks. He starts to beg Caitlyn to let go of Elwyn. Caitlyn refuses. She says no. And at this point, Dustin's internal radar is going off. Caitlyn is refusing to release their child. She's physically restraining her. She's putting her at risk. And Caitlyn has been acting suspiciously. She's been acting the same way that she did last time she kidnapped one of their children. Caitlyn is beginning to become a threat. Dustin is a Marine. He's trained to respond to threats, and he's responding at this point in the way he has been trained. He's at condition orange. He feels there is a danger to his child, and at condition orange, he's focused in solely on that threat and his need to protect his child. Dustin is begging and pleading with Caitlyn to just let Elwyn go. And Caitlyn again refuses. Caitlyn tells him that unless he pays her $2,000 a month, she is taking the children back to Minnesota and he will never see them again. Let's be clear, she is not asking for child support. She is not asking for money to help her take care of the children. She is asking for money so that he can have the children. She's asking him to pay her money so that he can keep the children. At this point, she's holding Dustin's child hostage, holding her for ransom, saying that she'll only release her if he gives her money. And she's also threatening to call the police and to lie to them, to tell them that Dustin took Elwyn to Berlin without permission, and that she's going to lie to the police unless he gives her money. And while she's threatening to take his children from him and make sure that he never sees them again, she's continuing to confine, to restrain their child. Dustin feels like this is a hostage situation. Elowyn isn't safe. He's panicking. He keeps begging and pleading, begging Caitlyn to just let Elowyn go. She refuses. She continues her threats that Dustin will never see the children again, that she is taking them from him. And she continues to confine Elowyn in her arms. At this point, the tension is rising. Valen is crying from her car seat in the other room, and Elowyn is crying, both from the argument and from being physically restrained by Caitlyn. The situation is overwhelming. Dustin is scared for Elowyn. He needs to make sure that she's safe. His fatherly instincts, his protective instincts, are telling him that something is seriously wrong. The woman who kidnapped his child before is telling him she's going to do it again. And this time, he can see her physically holding their child hostage. Dustin, trying again to protect his daughter, tries to take Elowyn for the second time. And Caitlyn pulls her, yanks back again, and Dustin lets go. Caitlyn continues her threats to take the children and ensure that Dustin never sees them again. Caitlyn is escalating. She's getting more and more aggressive. She's kidnapped one of their children before. She's threatened to take them from him before, but this time is different. This time, she's holding his daughter hostage, holding her for ransom right in front of him. This time, she's confining his daughter, restraining his daughter, using physical force against his daughter. And Caitlyn had been on the phone. Dustin's thinking, is there someone outside, maybe Brenda, waiting? He's thinking, she's saying she's taking my kids from me. She must have a plan. And Dustin tries one more time to take Elowyn, to free her, to make sure she's safe. This time, he tries harder. He tries to grab one of Caitlyn's wrists with one hand and wrap his arm behind Elowyn with another so that he can free Elowyn from Caitlyn's restraint. But instead of letting go, Caitlyn gets more aggressive, more physical. Caitlyn braces her leg against the table. She yanks back even harder than she has before. She pulls, she twists, she bear hugs Elowyn. And Elowyn lets out a scream, a cry of pain from being yanked back by Caitlyn. Dustin and Elowyn lock eyes, and Dustin sees Elowyn's fear and her pain. And hearing Elowyn scream is horrific. It's a line that has been crossed. Elowyn is about to be kidnapped. Elowyn is in immediate danger. And so Dustin acts immediately. And he very, very quickly, with deliberate motion and without conscious thought, acts the way that he has been trained. The only thing in his mind is save Elowyn. His internal radar goes into condition red when a threat is so immediate, a danger so imminent that you need to take action. Like he had been trained, instinctually, automatically, he grabs his gun, chambers around, grabs the collar of Elowyn's shirt with one hand, and pulls her as far toward him as he can while Caitlyn is still restraining him. And while Elowyn is still in Caitlyn's arms, still being held hostage, he fires a single shot. And immediately after he shoots, Elowyn is released from Caitlyn's arms and she is freed. Elowyn wraps her arms around Dustin and he runs out of the house and puts her in the car. He talks to Elowyn and makes sure that she is physically unharmed. But he's still in this heightened mode, this need to protect his kids. He grabs what he thinks they would need, he puts Valen in the car, and he drives. And once he's on his way, once he knows both kids are safe, once he's out of condition red, he feels horrible. What has happened is tragic. Caitlyn is someone he cares about and who is important to him and his children. He knew that he had been acting to save Elwyn, but that doesn't mean he isn't devastated by what just happened. And he knows he needs to turn himself in, but he wants to spend some time with the girls first to make sure that they are unharmed, to make sure that they are okay, not just physically, but mentally. He calls his mom. He tells her he shot Caitlyn. He tells her to call the police. And then he turns his phone off so he can have some time with the girls. And he drives, checking in on the girls along the way. The following morning, he turns around and heads back to New Hampshire to turn himself in. And he is hoping to have a meal with the girls before he does so. But the police locate him first. He cooperates, he complies with their commands, he makes sure they know that there are children in the car and exactly where his gun is located. And he does these things to make sure his children are safe. And then he speaks with the police, voluntarily, although he's under no obligation to do so. He's still in shock when he tells them what has happened. He feels horrible about what has happened, and he doesn't want to blame Caitlyn. He doesn't know New Hampshire's law on justification, and he doesn't know the law of defense of others. All he knows is that he was acting to protect Elwyn. When the state played the video of his interview, the last thing we heard Dustin say was about Elwyn. He says, not that it even justifies anything, but it's like, she's just my everything. And Dustin's right that Elwyn is his everything, but he doesn't know the law. The law says that Dustin is justified. The law says that Dustin is not guilty. The judge will instruct you on the law. He will tell you, evidence has been presented that Dustin acted in defense of another with respect to each of the charges. He will tell you that you must find Dustin not guilty unless the state proves beyond a reasonable doubt that he did not act in defense of another. And the state cannot meet its burden. Dustin did act in defense of Elwyn. He is not guilty. The judge will tell you that when looking at the evidence that Dustin acted in defense of Elwyn, you should consider all the circumstances surrounding the incident. You should consider how he acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. The judge will tell you that Dustin had the right to use deadly force to defend Elwyn if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin's belief that Caitlyn was about to commit a kidnapping was reasonable. Dustin had the right to use deadly force. Dustin is not guilty. And consider all the evidence you've heard that Caitlyn was about to commit a kidnapping. And I'm going to highlight just 4 of the many things that you've heard. First, Caitlyn's own aunt told you that Caitlyn had a plan to take the children to another state without telling Dustin. Second, Caitlyn had kidnapped one of their children before. Caitlyn had taken one of their children, pretended she was going to the park, and actually gone to the airport to take Valen out of state, to move her to Minnesota without even letting Dustin know. Third, Caitlyn was holding Elwyn hostage, telling Dustin he was never going to see either of their children again. And fourth, Caitlyn was willing to harm Elwyn rather than let her go. Caitlyn was in fact attempting to commit a kidnapping. We heard it from her own family member. And therefore, Dustin's belief that she was about to commit a kidnapping is not only reasonable, it's correct. During jury selection, we talked about the fact that parents have a responsibility, a duty to protect their children. And that's what Dustin was doing. He was protecting his child, ensuring she was not kidnapped. The facts are clear. Caitlyn was about to commit a kidnapping. You heard it from Brenda, and you heard it from Dustin. The law is clear. Because Dustin reasonably believed that Caitlyn was about to commit a kidnapping, Dustin had the right to use deadly force. Dustin is not guilty. The state gets to make its closing argument last, and Dustin won't have the opportunity to respond. So let's talk a little bit about what the state is likely going to say and about the evidence the state presented or didn't present during the trial. First, you should not automatically believe that what the state is telling you is correct. The state showed you that in its opening statement. The state's claims about what the evidence would be in its opening statement were wrong, and they were misleading. Here's one example of when they were wrong about the evidence. The state told you, even put up on its big fancy screen, that Dustin was asked, "Fair to say you know you are endangering Elwyn," and that he said yes. But the sergeant, the police officer, the state's own witness, told you that what actually happened was the exact opposite. Dustin said, "Could it be that I'm endangering Elwyn by what I did?" And I would very much say no. Dustin was asked, "Fair to say you know you weren't endangering Elwyn," and that's what he said yes to. What the state told you about the evidence was wrong. What the state told you about the evidence was misleading. It told you that Dustin said the shooting was very deliberate, but it didn't tell you that that wasn't all he said. He said it was very, very fast, very deliberate. And that was misleading. That left out half the sentence to create a misimpression. The state also got it wrong when they said that Dustin grabbed Elwyn, she was in his arms, he stepped back, and then he shot. That's what the state said happened in its opening statement, and that's not what happened. And the state knows that's not what happened. The state had proof in their evidence that what they are saying happened is not true. Their claim that he had Elwyn in his arms and stepped back is not true. How do we know that? We know that because the range of fire was close enough that Caitlyn's hair got caught in the slide of the gun.
Objection. May counsel approach.
Wow, did she not have a good opening statement? I thought she did. She had me convinced. I was making. Wow, did she not have a good? Oh God! Statement? I thought she did. She had me convinced. Okay. I was making. Wow, did she? I forgot I had my TV going in the background, but I was getting my water. And I didn't hear what happened. Would they get sidebarred? Oh, yeah. Sidebar lady. She had it already. Anyways, what do you guys think? Do you think she's giving a good closing argument about the law in New Hampshire? I mean, she's explaining to everybody that keeps thinking that he didn't have a right to think that his child was being kidnapped. Look at all the things Caitlyn has done. Granted, what happened was wrong. It was way wrong. Okay, gotta go.
Members of the jury, I'm instructing you, I'm striking the last sentence from the closing argument and instructing you to disregard it, and I will return to my seat now. Okay, thank you.
This is State's Exhibit 24A. They didn't talk to you too much about State's Exhibit 24A. They talked to you about the gun, but not about the other half of the picture. The other half of the picture says, hair removed from slide. So if you will take it back with you, and you can see it right now. The police tampered with the evidence. They took the hair from
Objection.
the slide.
May counsel approach?
Yes.
Oh, okay. So I went back and re-listened to what caused the objection, and she said that they knew that the little girl wasn't in danger because Caitlyn's hair was in the slide of the gun, so he was close range, right there. And now I have to go back and listen to why the objection now. Here, let me go back real quick. She said the police tampered with the evidence. Oh my God. And did you see the smirk on her face when she looked at the state, when she said objection? She smiled at her because she knew she got it. The jury's heard it. Whether the judge tells them to disregard it, they sorry, I'm excited. The jury's heard it. It's already embedded in their brain. Oh my God. This is some wild, wild closing arguments. You got sidebar lady going at it. Okay, I gotta go I gotta get some breakfast in me. Hold on. So who wants to say that the judge is schooling her right now on that? He's mad. Y'all, why did my toaster not even toast my bread? Because my dumbass forgot to set it up higher. Ah, I got warm toast. I bet he's schooling her.
Excuse me, members of the jury, I'm striking the last sentence of the defendant's closing argument based upon the totality of the evidence that has been submitted. Also, there was no evidence adduced during trial of any improper action in the collection of forensic data. Attorney Kettles, you may proceed.
States 24A shows that hair was removed from the slide.
The state didn't present any evidence that it tested the hair. The state didn't present any evidence about whose hair it was. The state didn't have its witnesses talk to you about the hair that was removed from the slide of the gun. And the state didn't talk about the fact that hair had been removed from the slide of the gun during its opening argument. And we can't know whose hair that was because the state didn't present any evidence, because the state didn't test it. But we can think about whose hair it must have been. We can think about where Dustin said his arm was when he fired, and where Caitlyn was in relation to that gun and the slide of that gun. We can think about the fact that Caitlyn's hair wouldn't have gotten caught in the slide of the gun if he had grabbed Elwyn, taken a step back, and then shot. Caitlyn was still holding, still restraining, still confining Elwyn when Dustin shot her. Dustin was justified. Dustin explained to you that Caitlyn was still bear hugging, still restraining Elwyn when he fired the gun. He explained to you that he pulled onto the collar of Elwyn's shirt with one hand to pull her forward to try to get her, but that she wasn't released from Caitlyn's arms. She wasn't safe until after he shot. The state may try to argue that that's not what he told the police, but you have the video. Watch it. They say that he stepped back. Nowhere in that interview does it say that he stepped back. Nowhere in that interview does he say that Caitlyn had let go before Elwyn was shot. I apologize, that Caitlyn had let go of Elwyn before he shot. I expect the state will make a big deal of the fact that the medical examiner told you that there was no evidence of close-range firing. But that just means that some of the markers that the medical examiner would look for weren't there. The medical examiner told you that he couldn't say exactly where the shot was fired. He said that it's possible, he said on cross-examination, that it's possible to fire from close range without those markers being there, especially when there is hair overlying the entry wound, like there was in this case. There wouldn't be gunshot residue on the skin if there was hair in the way, and there's been no evidence presented that the state tested Caitlyn's hair for gunshot residue. You have better evidence than a medical examiner, who can't say anything with 100% certainty, who wasn't there, who doesn't know whether or not this was justified. You have the photos from the apartment and from the autopsy. I'm not going to put them up again, but Caitlyn was sitting on the couch facing forward. She was shot in the side of the head. Dustin couldn't have had Elwyn in his arms, taken a step back, and then shot. If he had done that, she would have been shot in the forehead from the front. Instead, what happened, what the evidence shows, is that Dustin was grabbing Elwyn's collar with one arm and shooting with the other, while Caitlyn was still confining and restraining Elwyn. It's the only thing that makes sense with all of the physical evidence, that which was presented to you and that which was not, and which was not tested. It's the only thing that makes sense with the location of the gunshot entry wound and exit wound. It's the only thing that makes sense with the trajectory of the bullet down through the drawers. The state's got it wrong when it describes where Dustin was and where Elwyn was when the shot was fired. The evidence that the state presented about what Elwyn says happened also gets it wrong. It's also misleading. The only evidence the state presented about what Elwyn says happened comes from a doctor, not from a police officer or an investigator. Let's go over exactly what Dr. Robertson said. Dr. Robertson was leading Elwyn. She was asking her pointed questions, trying to figure out whether she had any medical issues, based on the only information the doctor had at the time, which was that Dustin shot Caitlyn. Dr. Robertson did the best exam she could with that limited information. Dr. Robertson said that she asked Elwyn if there was anything wrong with her, and at first, Elwyn said no. And only after Dr. Robertson guided her, led her to the answer, did Elwyn eventually say that her ear hurt and pointed to her left ear. Dr. Robertson had to ask her a very specific question to get that answer. She had to ask her how her ear got hurt. And Elwyn answered that question. She said, Mom and Dad were fighting, and Dad hurt Mom and me, and there was a lot of blood. And Elwyn's ear hurt because she had heard a gun that Dustin shot. That's not up for dispute. But think about what Dr. Robertson didn't know to ask. Dr. Robertson asked Elwyn if she was hurt anywhere else on her body. And Elwyn said yes. But Dr. Robertson didn't know what else had happened. She didn't know that Caitlyn had grabbed Elwyn, yanked her, pulled her, twisted her, made her scream in pain. And so the doctor couldn't get the right information out of Elwyn. The doctor didn't know what questions to ask to help Elwyn explain why else her body hurt. Elwyn was just 4 years old, and the doctor, who didn't know everything that had happened, couldn't ask her the right questions to get the full story from her. The state didn't have Elwyn testify. They didn't present testimony of any police officers or investigators who had spoken to Elwyn. They didn't give you the full picture of what Elwyn said. They gave you one small glimpse from a doctor who was there to treat Elwyn, not to interview or investigate. And the doctor didn't know what had happened and didn't know what to ask. You didn't hear the full story of what Elwyn said. The state also presented evidence in a misleading way when it cross-examined Dustin. It tried to suggest that Dustin never told the police that Caitlyn threatened to take the kids. But Dustin told the police over and over again that Caitlyn threatened to take the kids. You have Dustin's statements to police in evidence. And here's the rough timestamps for all the times, not all, but some of the times, when he tells the police that she threatened to take the kids away from him, both before the incident and during. 28 minutes and 13 seconds, he says, she just kept threatening, well, okay, I'm going to take the kids away. 28:47, he said, every month it was basically the same thing of her wanting more money with threats of taking the kids away. 31:11, he said, she was basically threatening to put me in prison and take the kids away. 32:39, she threatened to arrest me and take the kids away. He starts discussing the day of the incident. 59:18, she started getting more and more aggressive about how, no, I'm going to take the kids from you. An hour and 16 seconds. The one thing that does set me off is these continued threats of taking the kids away from me. An hour, 1 minute, 58 seconds. Her just again threatening to take the kids and saying she just wasn't going to leave and that she wasn't going to leave and that she was going to take Elwyn and Valen back to Minnesota. By an hour and 32 minutes into this interview, he said it so many times that the police start talking about how she's threatening to take the kids away. Dustin told the police, and he told you, that she threatened to take the kids away over and over and over again because that's what happened. I've given a lot of timestamps, but I'd ask you to take a listen to the video around 1 hour and 40 minutes. That's when Sergeant McLaughlin asks, and I'm quoting, the training you're talking about is marksmanship training, not specifically hostage? Because that's my first thought, was you're trying to remove Elwyn from a harmful situation. Do you have training in hostage-type scenarios? That's the investigating officer's first thought, that Dustin was trying to remove Elwyn from a harmful situation and wondering if he had training in hostage-type scenarios. That was the police officer's first thought, because Dustin was trying to remove Elwyn from a harmful situation, from a hostage-type scenario. Think about the evidence that the state didn't present to you. The state didn't call Brenda. The state didn't talk to you about or present evidence of testing of the hair stuck in the slide. The state didn't ask the medical examiner about how hair impacts gunshot residue. The state didn't have a police officer who spoke to Elwyn testify. The state had Dustin's phone. They had his text messages with Caitlyn, his text messages with Lori, his text messages with Rob. but they didn't show them to you. They didn't want you to hear what they said. Those text messages prove that what Dustin told you is true.
Objection.
Well, if the state wasn't trying to hide stuff, there wouldn't have to be Miss Sidebar every 5 minutes. My God, stop hiding stuff. I think she's got a good closing argument, and anyone that had any, I guess I shouldn't be happy about it because there is somebody that had lost their life. But we have to remember, if somebody was trying to kidnap your child, would you not do anything you could to keep that child with you? Whether it be the mother or not, she said she was going to take his children and never let him see them again. Now, what would be going through your mind as the other parent? You have to put yourself in that situation. How would you feel if your husband had your child and said, I'm taking these children and you're never going to see them again? Because there are parents out there that will do that and have done that. And it's just unfortunate that not a lot of people, like she said, Dustin did not know the law in New Hampshire. That when in a situation where your child is being kidnapped, you can use deadly force. And apparently the judge is allowing that a parent can kidnap their own child. Because there has been so many situations out there where a parent has kidnapped their own child. So we have to put ourselves in both of their situations. Now, if there were problems and Dustin was giving Caitlyn problems, she should have called the police. She should have made a report for whatever reason was going on in that relationship that she felt she needed to kidnap her child. Go to the police station. It didn't have to lead to this. But I don't know much about the law, so I'm just going off of what they're saying, really. I don't know. But I just wanted to remind everybody that today, if we're not done by at least 2:20, I have to get off because I have to go to physical therapy. Not that I want to, because I feel really bad. I still feel really under the weather. That I will have to end the stream. Not that I don't want to. I can log into StreamYard from my phone, but I can't. There's no way for me to do anything but just end the stream from StreamYard. I can see it and talk, but exactly. You don't know. Everybody that's saying, oh, he's such a horrible man, such a horrible man. Why? Because he did what he thought was protecting his children? How does that make him horrible? Just like if I were trying to kidnap my child from my husband or boyfriend, and he were to use force against me, well, I suppose that's a chance I'm going to have to take in life, She took a chance. unfortunately, she's not here with us anymore, you know, and it's sad that it had to come to this. But I just feel there's so much more to this. Like she said, there's text messages that we didn't hear. And I feel that had they been that important, they should have been brought in, but the state fought to not let them come in. So the state's hiding a lot of stuff. And you don't know a case until you've heard every word and that jury goes to deliberate. Then you have the case. You don't have it from the first two sentences of the opening statement. Oh, he's guilty. I'm not watching it. No, it's not how it works. If you're going to watch trials, you have to watch them from beginning to end to know everything that happened. They're painting you a picture of what happened. You have to stay for that whole painting, and sometimes paintings can take a long time to make, to paint. And I think the defense painted a really nice picture. And unfortunately, the state left out a bunch of evidence that they couldn't use in their picture for the jury to use during their deliberations to see that this man was using deadly force because there was a crime of kidnapping occurring. Now, what if it wasn't Caitlyn that wasn't the kidnapper? Oh, well, then the crime would be fine, right? Then he's a good man. He was saving his child. But because it was the mother of the child, no. Then the law's against him. Well, how does that make any sense? I don't get that. She was breaking the law, then he broke the law. I don't know. That's just how I feel about it. But I'm not a very smart person, so don't believe anything I say. That's just how I feel. I don't like to give my opinion much because then it's just too controversial, and I don't like to be confrontational. I'm just talking to keep the time going here. I mean, we got sidebar lady here. She could be doing this all morning. I could have taken my shower. I'm tired, y'all. And I'm cold. I'm really cold. I should have turned the heat on in this apartment. Oh my God. But I'm not ready to turn the heat on. I don't even know if I can buy food next month. Have they come to an agreement yet on the shutdown? Probably not, huh?
Members of the jury, based upon the state of the evidence, I am going to strike the last sentence of the defendant's closing argument and instruct you to disregard it. Thank you.
I expect
Okay, so
the
it's not
state
a
is
bird,
going to
it's
try
that
to
guy's
argue
chair.
that Dustin didn't reasonably believe that Caitlyn was committing or about to commit a kidnapping because she was the children's mother and because there was no court order on custody. But that just doesn't make sense. Think about it. Imagine if Caitlyn's secret plan had gone into effect. Dustin would have woken up in the morning to both of his children gone, stolen, kidnapped, taken away to another state. We are talking about unlawfully taking children away from their father to another state permanently without him knowing. We are talking about coming up with a secret plan. We are talking about deception. We are talking about Caitlyn planning to commit a crime. Dustin reasonably believed that Caitlyn was about to commit a kidnapping. And the fact that she's the children's mother doesn't change that. The state's also got it wrong. They're missing the point when they spend hours and days focusing on cell site location data and testimony from someone who saw Dustin's car and presenting a whole lot of evidence of things that aren't in dispute, that Dustin told you happened. They're focusing on what happened after the shot was fired. But what matters in this case is what was happening immediately before and while the shot was fired. This whole case is about Dustin's defense of Elwyn, that Dustin was justified under the law. Dustin wanted to spend more time with his girls. That's not a crime. He's not charged with anything related to that. It's only human nature. It's a father wanting to make sure his kids are okay. He wasn't denying what had happened. He called his mom and told her. He knew his dad would call the police. He made sure they knew the girls were okay, and he told them that after he took some time with the girls, he was going to turn himself in. He didn't deny what had happened when he waived his right to remain silent and spoke voluntarily with the police. And he didn't deny what had happened when he took the stand here yesterday and spoke to you. Nothing that happened after the fact changes what happened in that apartment. It doesn't change that Dustin reasonably believed that Caitlyn was about to commit a kidnapping, that Caitlyn had a kidnapping plan, that Dustin was justified under the law. The state is wrong about whether Dustin's use of deadly force was justified. Think about Dustin's perspective. Think about what was going through Dustin's mind at the time. Dustin didn't think there was any help available. Dustin had spent months trying to figure out how to deal with Caitlyn. He called his parents. He called her parents. He called a lawyer in Minnesota and one in Vegas. He called the Berlin Police Department, and they told him they couldn't help. Think about that time a year or two ago when he called the police in Vegas and they didn't show up until after the threat was gone. Think about the fact that Caitlyn had kidnapped his child before and she had a plan to do it again. The judge will instruct you that you should consider how Dustin acted under the circumstances as they were presented to him at the time, and not necessarily as they appeared upon detached reflection. Consider how he felt at the time in that moment that Elwyn is screaming in pain. Consider his perspective as a Marine, his perspective as a father, whose child had been kidnapped before by the very same person who was holding his child hostage in front of him. And I'd imagine the state is going to talk a whole lot about other things that they think Dustin should have done instead. But think about what's going on here. Dustin tries to de-escalate the situation. He tries to talk to Caitlyn. She won't talk to him. He begs her and pleads with her to just let Elwyn go. And she refuses. He tries to just grab Elowin, and Caitlyn won't let him. He begs again for Caitlyn to let Elowin go, and she refuses. He tries to get Elowin a second time, a third, and the third time he tries even harder, grabbing Caitlyn's wrist with one hand and trying to pull on Elowin from behind. And it is only once Caitlyn physically harms Elowin, only when Caitlyn is willing to go to the length of letting her child be harmed, be hurt, to enact her kidnapping plan, that Dustin acts. Even when Dustin grabbed the firearm, even when Caitlyn heard him chamber around, she still didn't let Elowin go. Even when Dustin pointed the firearm at her, Caitlyn still didn't let go of Elowin. Caitlyn was still holding Elowin hostage even after he had taken those steps. Those steps of grabbing the firearm and chambering it weren't enough. So Dustin did what he had to do. Dustin reasonably believed the amount of force he used was necessary because nothing else worked. And again, you will be instructed to think about Dustin's actions under the circumstances as they were presented to him at the time, when he acted in the heat of passion. Consider the stress, the anxiety, the fear, and the need to take immediate action, to prevent Elowin from being hurt, to make sure Elowin was safe. Your role is not to Monday morning quarterback. It's to think about what Dustin was seeing and thinking and feeling in the midst of this horrific situation when he had to make a split-second decision and act instinctually. And from that perspective, Dustin did what he had to do to save his child. Dustin was justified. Think about the fear that Dustin felt, hearing Caitlyn tell him he was never going to see his children again, seeing Elowin restrained, confined, held hostage in front of him. And think about the fact that he did not take that action until Elowin had been harmed, until Elowin screamed in pain and locked eyes with him, until the line had been crossed. He was a Marine and a father responding to a threat. He was a Marine and a father protecting his beloved daughter. This is a tragedy, but it's not a crime. When you hear from the state, I ask you to keep in mind everything we've just talked about. I ask you to keep in mind that Caitlyn's own aunt told you that Caitlyn had a plan to kidnap the kids. Keep in mind that if Caitlyn had a plan to kidnap the kids, it was reasonable for Dustin to believe that she had a plan, that she was about to kidnap the kids. Keep in mind that the law says that Dustin had the right to use deadly force if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. The judge will instruct you that you must apply the law and that you must hold the state to its burden. When you do, you will return the only fair and just verdict, the only one supported by both the evidence and the law, one declaring Dustin Duren not guilty.
Mr. Duren will take a 10-minute break, Attorney Duren, 10 minutes?
That's fine, Your Honor.
10 minutes?
I'm ready now or whenever you'd like.
Okay, we'll take a break now, mid-morning break now. We'll reconvene at 10:25. Again, please do not discuss any aspect of the case or the evidence amongst yourselves. Please notify the bailiff. If anyone, you see anyone do that, we'll be in recess until 10:25. Thank you.
All right. So how are we feeling about all that? She just came back and said everything I just said when they were at the podium with the judge. I mean, it's all true. What if it wouldn't have been Caitlyn? What if it would have been someone else? Then it would have been justified. But it wasn't. It was the mother of the child, the children, and it's unfortunate, but there is the law. And the judge will read the law that in the state of New Hampshire, if you feel at threat of your child to be kidnapped, you can use deadly force. And apparently a parent can kidnap their own child, which is true. You hear Amber Alerts all the time of another parent kidnapping their children. So, yeah, that's how that goes. So I was reading, and they're going to vote again today to at least extend the shutdown to November 21st. And I do believe that will open up the food stamps for people that do receive food stamps. I just can't imagine how empty the stores are going to be November 1st. And then I wonder about people that are on Medicare, because I'm on Medicare. Or, I mean, I'm on Medicaid. Do we still get our Medicaid? I wonder. Oh, well. I was just going through some things in the news about what's going on in the world. I don't know. I think I might cancel my therapy today. I just don't feel good. Or maybe it's just I'm lazy. I don't know. I haven't quite figured it out. So the state is going to be up now and give their defense. And then the judge will give the jury instructions, which can take a while. And then the jury will get it. How long do we think they will be deliberating? Let's figure out how to do a poll. How do you do a poll? I don't know. Oh, yeah. Please remember to hit the like button, share this out, and comment, please. 5 more minutes. I'm trying to find things here to talk about, but a lot of them you just can't talk about on live YouTube. You know what I really want to get into? Making cake. Kathy says the state must not have had any proof of domestic violence or it would have been brought up. Exactly. I mean, you and I searched up and, well, you pretty much searched up and down every state looking, and all you could find was he stayed at a parking meter for too long and something about the girl, one of the girls. Don't sound like domestic violence to me. Did you guys hear about that LA detective? Oh, wait, we got another one. About the girl was for custody after he was incarcerated. I think both sets of grandparents share custody now. Oh, good. You're talking about the girl, the Ellarine and the little girl? I got a check coming in the mail today. He only had 2 parking violations. No other record. Okay, 2 parking violations. His whole entire life, 37 years old. 2 parking violations. Does that tell you how violent and they said that he was a very a man that got upset easy? Come on, I think if that was the case, he would have had a lot more on his background. Tell you what, I can show you someone who was violent. I've had my fair share of DV, and I'll tell you what, I honestly, even my daughter will tell you to this day, she didn't think I was going to make it out alive, but I did, and I'm here, and I'm working through it every day. YouTube is helping me. It's been a few years ago, but I still have a lot of trauma from him. A lot of flashbacks in my mind. Oh, it's muted. I forgot I muted it.
Okay, thank you. Please be seated. Again, let the record reflect, I'll be moving to adjust my position where I can maintain visual contact. Attorney Duren, you ready to proceed?
Thanks, Ron. Just checking, Your Honor, you're all set?
Yes.
Ladies and gentlemen, this was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he has changed what he told the police after he was caught to what he testified to on this stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head, who was sitting on the couch with a child. Now, yesterday, when he testified towards the middle of his cross-examination, he told you in his own words, live from the witness stand, why he shot and killed Caitlyn. And he told you that in that moment, right before he got his gun, right before he pulled the trigger, that she hurt his daughter. His daughter. If you listen to defense counsel's opening, I lost track of the number of times that they described this child as his daughter. Caitlyn Naffziger, according to the defendant, hurt his child. She hurt her by holding her tight, hurt her by pulling her close, hurt her by pulling the child away when the defendant tried to grab her. Turning it on helps. Let's be clear. Caitlyn was holding their child, her child as much as his. A child she carried for 9 months. A child she gave birth to. A child that she could hold and bear hug and be with just as much as he could. They had equal rights to these children, rights they had been arguing about since August of 2023. On the day that the defendant killed Caitlyn, he was angry. He was yelling. He didn't want to admit that during his testimony, right? I maybe yelled 1 to 2 sentences. The defendant needs to be in control. That is clear from his testimony. It is clear from his statement to the police. He is the person who operates best under stress. He needs to be the leader. He wants to have a plan, and you know what? Once a plan is made, there are no changes. Plans never change. But on that day, on February the 29th of 2024, the defendant was not in control of Caitlyn. You know, defense counsel stood in front of you and said, think about how he felt, that he might have to lose his children, that he couldn't hug them when he was taken into custody. He was asking Caitlyn to drop her child, the youngest one off, their child, with him, to then see her daughter, their daughter, who she hadn't seen in a month and a half, sleep over and leave. Think about that day and what the defendant's behavior must have been. How his frustration over the situation, over the change in plan, turned to anger over the course of a day. It must have. It doesn't make sense that it wouldn't have. He didn't want Caitlyn there in his apartment. He wasn't happy that she had spent the night. It wasn't part of his plan. He wanted her to leave. He testified and told the police that during that day on February the 29th, every 15 minutes or so, I think he said 15 to 30 on the stand, but he said 15 during his statement to police. Every 15 minutes for several hours, up to 5, he agreed with me yesterday, probably between noon and 5 p.m., he went to the room where Caitlyn was playing with their daughters, and he asked her when she was leaving. He hovered in the doorway. Her being there wasn't part of his plan. He wanted the girls with him, and he wanted Caitlyn gone. He told the police that. He told the police that he'd even discussed it with his mother. For at least 5 hours, every 15 to 30 minutes, he went to that doorway and he said, "When are you leaving?" He asked how she was leaving. When is her ride coming? And she was ignoring him. She wasn't ready to leave her children, their children, behind. The defendant was frustrated, but he became angry. He was angry because she wasn't doing what he wanted, wasn't following his plan. He was angry because she was ignoring his questions, because she didn't want to leave. He was angry because they were having the same dispute they'd been having since August of 2023. And Caitlyn, we know, apparently, didn't want to hand their 4-year-old daughter over to the defendant while he was yelling and angry, while he was pulling at the child and trying to yank her from Caitlyn's arms. Caitlyn knew how angry he was, and she knew that he was dangerous. She didn't know how much of a danger in that moment, but he'd show her. You know that Elowen told doctors at the hospital what happened. You know that she asked them to look at her ears because they hurt from the loud noise of the gunshot. Defense counsel wants you to believe that Dr. Robertson, somehow not knowing what happened, led Elowen to make the statement that she made. It simply doesn't make sense. You heard testimony from Dr. Robertson where she explained to you how she approaches a child. "Hi, I'm Dr. Natalie. Can you tell me what hurts?" That's not leading. That's not trying to get an answer from a child. It's trying to find out where they hurt and where to examine. And when Elowen was asked what hurt and where to examine, she said that mommy and daddy were fighting. She said that daddy hurt her and mommy, that mommy had lots of blood. Elowen didn't have any bumps or bruises from being held tight by her mother. She didn't say that mommy hurt her. She said daddy did. The defendant hurt them both, and he hurt them in the worst way possible. On February the 29th of 2024, Dustin Duren murdered Caitlyn Naffziger. He killed her as she sat on a couch in his living room. Remember the testimony. And ladies and gentlemen, you are the deciders of the facts, right? If defense counsel stands in front of you and they tell you something and you disagree with it, that's what you should do as jurors. You're the judges of the fact. If I stand in front of you and I say something that you don't agree was the evidence that you heard, that's what you should do. You should discard what I tell you and pay attention to the facts that you heard in testimony. But the facts that you heard was testimony from Dr. Weinberg, right? And he talked to you about close contact firing. And even under cross-examination, his testimony was that the defendant had to be 3 feet away or more from Caitlyn, and not just the defendant, right? But the tip of the gun. The tip of this gun had to be 3 feet or more away from Caitlyn's body, away from her head when it was fired. And so we know that the defendant stood at a distance when he shot her in the side of her head. When Dustin Duren fired a single bullet from this Beretta 9mm handgun, Caitlyn Naffziger was wrapped up on the sofa in their daughter's pink unicorn blanket. Her foot was on the coffee table. She had no shoes on, and there were none close by. She wasn't threatening anyone. She had no gun, no knife, no weapon of any kind, nothing. She wasn't even looking at the defendant. You know, defense counsel stood in front of you and said, well, if it happened the way the state described, well, then Caitlyn would have been shot in the head. Well, not if she wasn't a threat, not if she wasn't watching him, not if they weren't engaged in any kind of dispute or argument like the defendant has said. We know from the evidence that she was shot here in her temple. That's what the doctor can tell you. In terms of positioning, that's based on how they were interacting at the time, and Caitlyn wasn't looking at Dustin Duren. The defendant's bullet entered the left side of her head at her temple. It traveled straight through her brain. When the bullet exited on the right side of her head, it took pieces of her skull with it. The bullet continued in a straight line, cutting into the built-in bookcase behind her, ricocheting through the drawers. You know, Caitlyn was likely dead before Elowen even saw the blood, before Elowen began screaming about the noise of the gunshot hurting her ears. The defendant didn't check to see if Caitlyn was alive, to see if she could be saved. Instead, he ran. He loaded his car with changes of clothes. More than you needed for one night, more than you need for 2. He put his desktop computer tower in the trunk. He turned out the lights, he turned the key in the deadbolt and locked the door. He drove south. He went dark. You know, defense counsel made it a point that you didn't need to know about his phone searches or his phone records. You know what they told you, those records? They told you when he left his house, which gives you an idea of when he killed Caitlyn. Those records that you have in evidence show you that around 6 o'clock, between 5:30 p.m. and 6 p.m., on the 29th of February, the defendant began to leave his home. Caitlyn was dead, and he was on the run. A person who's justified, who acted lawfully, who acted to defend someone, they do not run. They stay in place. They do the right thing. They ended the threat. They call the police and they tell them what has just happened. It's the first thing that they say. They yell it at the top of their lungs. They scream that they had no other choice. But the defendant didn't do that, and he didn't do that because he had choices. There were options that didn't involve putting a bullet through an unarmed woman's head. He knew then that what he had done was not justified. It wasn't in defense of someone else, and it wasn't to stop a kidnapping. It was a murder, and he acted like a murderer. You know, a murderer packs their clothes and drives through the night with 2 little girls after he has killed their mom and left that mom dead in his living room. A murderer turns off his phone so the police can't find him. A murderer needs 16 hours to tell the police that something happened. And that's how long Dustin Duren had. From 6 p.m. or 5:30 p.m. when he left that house until he was taken into custody at 10:30 the next morning, he had 16 hours. But you know what's even more is a murderer needs 3 hours of background testimony at a trial before he can tell his new version of what happened.
Can I have your coach?
What? What? You aren't sidebar lady. Oh, we were doing so good. We were doing so good. And then I just found out my YouTube Premium took their money on an account that doesn't have money in it yet. Jeez. I don't know, but she's just saying the same thing that the other lady said, just in a horrible way. I feel like I've been sick for years. I just told my boyfriend on the phone, I said, maybe it's time we go to the doctor and find out what's going on. Because apparently we're not getting better. Jeez, even the dog is sick. Sick and tired of us. He don't sound good. Sounds like he's getting sick again. He's a sickly person. I don't get sick. It gets brought to me, and then I get sick. That's what makes me mad, because I don't go anywhere. I don't do anything. But I always manage to catch it. Okay, let's go.
A murderer needs 1.5 years to explain that his actions were an act of defense of others. Ladies and gentlemen of the jury, the defendant thinks in this case that he can fool you, that he can put this claim of defense of others in front of you, and that you will jump on it and detract from his actual actions and his intent. When you were chosen as jurors in this case, each of you individually, you brought your life experience with you. You brought your ability to make assessments and to make judgments, and you brought your common sense. We keep a lot of things that you're not allowed to bring with you into the courthouse or bring with you into the jury deliberation room, but your common sense isn't one of those things. Your common sense and your knowledge about people, it stays with you when you come in the courthouse. It stays with you here in this courtroom, and it will sit with you as you go into that back room to deliberate. Your common sense and your experiences is why you were selected. And it gives you a framework and a basis to evaluate what happened on February the 29th of 2024. This is a framework that you can use to evaluate the witnesses, the testimony, and the evidence. Your common sense plus that evidence and plus the court's instructions are the tools that you have. They're the only ones we give you, but they're the tools that you have to fairly and impartially weigh the evidence in order to determine whether the state has proven beyond a reasonable doubt in this case that the defendant killed Caitlyn Naffziger, and that when he did that, he was not acting in lawful defense of others to prevent a kidnapping when he shot her in the head. You, as I've explained, are also the judges of fact, and that is why you use your common sense to evaluate that testimony. You give the testimony of each witness what you believe it deserves, not what the state tells you and not what the defense tells you. In terms of the first part of your job, determining whether the state has proven beyond a reasonable doubt that the defendant killed Caitlyn Naffziger, at the beginning of this case, we stood in front of you, my colleague, and told you that this is not and would not be a complicated finding for you. This isn't a whodunit, that by the conclusion of the evidence here, you would know beyond a reasonable doubt that the defendant is the person who shot and killed Caitlyn Naffziger. Throughout the past week, you have learned that he confessed to his parents, he confessed to the police, his gun is the murder weapon, that he knows that when you point a gun at a person, you intend on killing, that he knows exactly where the bullet went, and that he has testified now in this case that he is the one who fired the shot. You know beyond a reasonable doubt that he killed Caitlyn Naffziger. The defendant is facing several charges related to this case. Those charges include second-degree murder, reckless conduct with a deadly weapon, and endangering the welfare of a child. The judge has explained some of the law to you, and shortly he's going to explain to you what it means to commit second-degree murder. The defendant, to be clear, is charged with two variations of second-degree murder. He's charged with knowing second-degree murder and reckless second-degree murder. The difference is in what he was thinking at the time that it happened. The court will talk to you about those charges of reckless conduct and endangering the welfare of a child, and those charges, so that you understand, are related specifically to the defendant's actions in which he placed 4-year-old Elowen in danger or violated a duty of care that he had to her. The facts of this case as presented to you over the past week and a half, have demonstrated that each of the requirements that you need to find the defendant guilty of these crimes beyond a reasonable doubt have been met. Let's demonstrate what I'm asking, or what the state, what everyone's asking you to do here. I want to look at the factors of second-degree murder. Up on the screen you have in front of you part of what the judge will instruct you on. The judge is the judge of the law, just like you are the judges of the fact. So his instructions will hold, okay? Now you have to decide whether the defendant caused Caitlyn Naffziger's death. Again, this has been proven. The defendant admits that he was the person who pulled the trigger, that he shot Caitlyn in the head, he caused her death. For knowing second-degree murder, you also have to consider whether the defendant acted with a knowing intent to cause her death. That means that when he fired the gun, he was aware that such conduct would cause Caitlyn's death. You should consider all of the evidence that you've heard throughout this case when you decide whether the defendant knew that he would cause Caitlyn's death by shooting her that day. You've heard about the defendant's ability with a gun, his military training. He testified that he raised the gun, and he admitted that the purpose of pointing a gun at someone is to kill. There is no other purpose. He knew that this would be the result when he pointed his gun at Caitlyn and when he pulled the trigger, He knew exactly where the shot would go and the damage that it would cause. For each of the charges that we're talking about, the court, you must also consider the defendant's claim that he was acting in defense of others. Specifically, the judge will instruct you that in this case, acting in defense of others means that the defendant had to not just reasonably believe. Now, defense talked to you in their closing about reasonable. It was a reasonable belief, a reasonable belief. But you'll note that on the screen, and as the judge will advise you later, that there's actually another portion of that. The defendant's belief has to be an actual belief and a reasonable belief. We expect and anticipate that, the defendant testified from the witness stand that all he had about this kidnapping plan or kidnapping idea were his suspicions. Suspicions are not an actual belief, they're just suspicions. The defendant didn't have an actual belief here, and he didn't have a reasonable belief here. And if he didn't have those two things, if his belief wasn't actual, if his belief wasn't reasonable, then he was not lawfully acting in self-defense, and his murder of Caitlyn is not justified. There was a lot of discussion about where Elowin, where the 4-year-old is at the time that the defendant fired. And that's one of the things that you can consider, both in the charges of reckless conduct and with respect to the defendant's claims. At the time that the defendant had fired, if we look specifically at his claim that Caitlyn was kidnapping, right? At the time that the defendant had fired, he had grabbed Elowin with his left hand, and he shot Caitlyn with his right. With that action, the defendant ended any argument he might have made that he had shot Caitlyn to prevent a kidnapping. It was over, it was done, and he had the child. But it's the state's position that there was never any kidnapping. Caitlyn was never about to commit a kidnapping. She was not about to do anything. She had made her position clear to him. She was refusing to leave, and she was seated on the couch holding their daughter. In the defense's opening statement, they told you that the defendant pulled Elowin to safety before he fired. He told the police in his statement that he had grabbed her, pulled her back, and then shot. But yesterday in his testimony, he stated that he had just pulled her forward by her shirt and held her in place. He implies that she was still on Caitlyn's lap when he fires the gun. But the defendant's testimony doesn't fit with the evidence. Dr. Weinberg testified that he found no evidence that the shot occurred within close range. He testified even on cross-examination that his opinion was that it had to be 3 feet or more away. He found no evidence of stippling. Now, this isn't gunshot residue, it's stippling. Little burns of gunshot powder embedded into Caitlyn's skin or face. She didn't have any. There was no stippling on Caitlyn's wound. There was no stippling on her face, her neck, or anywhere on her. Dr. Weinberg found no evidence of soot deposits on her face, and he testified to you that based on his examination of her body, the muzzle of the gun had to be at least 3 feet or more, not closer, 3 feet or further back when it was fired. And if the shot came from 3 feet or more from Caitlyn's body, there is no possibility that Elowin is on Caitlyn's lap when the defendant fires. Elowin was in his arms. Even if the defendant had fired the gun in the way that he demonstrated or tried to demonstrate from the witness stand yesterday, he would have been closer to Caitlyn than 3 feet. The gun would have been closer still. Just as he told the police, the defendant grabbed Elowin and pulled her back. The defendant then had to step back to shoot Caitlyn Naffziger from the distance that her body shows the shooting happened from. Now, I want to talk to you a little bit about defense counsel's desperate efforts with respect to State's Exhibit 24A to talk about a hair on the slide. No one knows whose hair this is. No one. Defense counsel does not have to put on a case. They do not have to bring up evidence. But if this hair was the linchpin that solved it, they had every right and could have. And they chose to put on a case.
Objection, burden shifting.
Roach.
Yeah. Okay. Okay, sidebar lady. Here you go. It's your time to shine. Oh, I can't stand that lady. But whose else hair would it be if it wasn't Caitlyn? She was the only one there and the only one that was, unalived. Whose hair could it be? Oh, it's not Mojo, Bob, Mike, Brenda down the street. Oh, I better take my blood pressure meds. They getting on my last nerve. Yesterday I don't know what I was doing in my medicine thing here, and I spilled all my lisinopril at the bottom of my bucket. Still can't believe it. Leah, go to the kitchen, get in the refrigerator, and get mommy shot. Okay, go get mama shot. Hurry up. Y'all, do you know anybody who's been sick for like 2 weeks? Yeah, it could have been from a long time ago. Yeah, you're right. How many times has she shot it next to somebody's head? No, I'm just kidding. It could have been picked up from inside the car. Didn't he have it in the car on the side of the door? It could have been one of the little girls from the hair flipping in the wind when they were flying down I-95 to God knows where. They were traveling during their little escapades while Caitlyn was in the sky with the other one. God, this case, you all. Sometimes you just have to laugh. Oh my God. It's just crazy. This case is crazy. I don't know. Didn't they offer him something else that he could have possibly have taken? Like manslaughter and given him 20 years or something? I mean, I don't know. Like manslaughter is not even on the table. My rib hurts from coughing. Yeah, it does. I have a heating pad on it today. But I am going to try to go to therapy, though. So, hopefully they can be done by 2:20. I mean, I have to fit a shower in some point.
Members of the jury, I'm going to strike the last sentence from the state's argument and two other comments. The defendant had no burden to test any evidence in this case. And in fact, the defendant has no burden to produce any evidence in this matter. So with those instructions, I'll allow the state to continue.
Thank you, Your Honor. Ladies and gentlemen of the jury, defense counsel kept showing you this photograph, the word hair, because there was a hair in the slide. And they want you to somehow put together and believe that that is Caitlyn's hair, because that would somehow show you and prove by their theory that the defendant was closer than 3 feet. That you should use the fact that there's a hair on the gun, a gun that was next to the defendant, next to his child, in a pocket inside of a door in a car, and that you should somehow use this missing hair that hasn't been tested to decide that that means he was closer, that you should use this hair to disregard the testimony, the evidence, and the expert opinion of Dr. Weinberg. That doesn't do this. There's no inference as to whose hair. You know, I think we all understand, especially possibly the women on the jury, that hair falls out. It's everywhere. Hair on a gun isn't an inference that you can make. It doesn't matter whose hair it was. None of it would show that Dr. Weinberg's testimony is called into question. Dr. Weinberg, who testifies that this gun, the muzzle of it, the very tip, was at least 3 feet away from Caitlyn when it was fired. 3 feet from here to Caitlyn. You can make reasonable inferences from evidence. You cannot make jumps or wild conclusions. You have State's Exhibit 26B in evidence. That's the defendant's statement. This is an image from that, just showing you him in that room where he was interviewed, in that room with police officers on March the 1st of 2024. He didn't claim during this interview anywhere, at any time, that he acted to defend somebody, that he acted to protect Elwyn from being kidnapped. The defendant didn't shout it at the top of his lungs. He never once said he acted in defense of anyone. Unlike in his prepared testimony Friday of last week and yesterday, the defendant didn't tell the police that Caitlyn was kidnapping anyone or about to kidnap anyone. He also didn't tell the police about his suspicions or make hypothetical statements that someone might be outside of his apartment. He didn't tell the police that she was demanding that he pay her money in that moment. He talked a lot about times she'd asked for money in August of 2023, in September, October, leading up to this incident, but he never said those demands happened before he shot her. He didn't tell the police that she was demanding that he sell his car and give her money. He didn't tell the police that before he shot her in those moments, that he'd never see the kids again. These are all statements that he added over a year and a half later in support of his defense to excuse his murder of Caitlyn. You remember when he was specifically asked in that statement, if Caitlyn was threatening anyone or causing any harm, he said no. He never once said he had to act to defend anyone. He never once mentioned a kidnapping. Not until yesterday in this courtroom did he make that statement. And even then, if you remember his testimony, he didn't say that he acted to shoot because his daughter was being kidnapped. He stated that he had shot and killed Caitlyn because in that moment, she was hurting Elowen. You know, the defense has argued to you that Brenda Plamondon and Caitlyn Naffziger formed some kind of secret plan to take the children. Their plan involved code words and planned 911 calls. And it never happened because Caitlyn never called. You know, for a plan to be secret, the people involved in it don't tend to broadcast what they're about to do, don't tend to stand in front of the person they're about to steal a child from and say, I'm going to call the police, I'm going to take the kids. You know, about that plan, what defense has termed as a secret plan to go along with the broken promises because Caitlyn wasn't following the defendant's plans. The word plan comes up a lot, and I apologize because it's hard to keep them all straight sometimes. But Caitlyn never called Brenda. She never texted her. She never asked for help. She never sent a code word, and Brenda never called 911. More important to your consideration, defense counsel advised you're not to Monday morning quarterback the defendant's choices, right? You're only to consider what he knew in that moment. And so if he didn't know that Brenda and Caitlyn had talked about this code word and 911 call plan, then he didn't consider it in the moments before he shot. What you do know is that the defendant didn't know about it and that it never actually happened. And because of those things, because he didn't know, you cannot use it to make the defendant's now stated belief that the defendant was going to kidnap the children become an actual belief or a reasonable belief. You know from his testimony that he only had suspicions. He didn't act on an actual belief, and his belief and his actions were not reasonable. On March the 1st of 2024, 16 hours after he had murdered Caitlyn, the defendant drove from Vermont into Keene. He told you that he was on his way to turn himself into police, to turn himself in for shooting and killing Caitlyn. He drove past multiple police stations in multiple states. He drove past the New Hampshire State Police Barracks at Troop C. He wanted to be arrested on his own terms. He knew that he would be taken into custody. He knew there would be an investigation, and he was ready for that. That's why he came back. He knew that speaking to the police was his opportunity to provide a statement about what had happened, his statement, and he wanted that opportunity. He wanted to speak with police and tell them why he shouldn't be in trouble for what he had done. But he didn't turn himself in. He got taken into custody at gunpoint in front of those two little girls whose mom he had killed. He had 16 hours to think about and prepare for this moment. He had 16 hours to determine what to say, what exactly to say and how to say it. He'd given himself the time and the space to put any spin that he wanted on the events that occurred in his living room. He'd had time to consider what it was he was going to tell police, how he would portray himself, how he would portray Caitlyn. Besides his 4-year-old daughter, there was no one to contradict him. And so he waived his Miranda rights. He spoke with investigators for over 2 hours. They let him talk about anything he wanted to address and just asked him questions to fill in the blanks. This was the defendant's opportunity to tell them why he had killed Caitlyn. He said, she refused to leave. He said she was bear hugging their daughter, that she wouldn't let go, that he tried to pull the child away. If you listen in the tape, there's about 40 minutes where he talks about their background and his disputes with her and their custody issues. It's not until almost an hour in that he actually starts talking about the moment that Caitlyn was in his apartment and leading up to his killing of her. In those moments, at around, I believe it's 1 hour and 4 minutes, the defendant says he was trying to grab Elowen and be like, hey, let go of Elowen, and she just wouldn't do it. And that was kind of the tick. And then he says, I think the moment was definitely very deliberate and fast. It was like the line had been crossed. That her not letting go, her continuing to hold Elowen, was the only thing, the tick, the moment in his mind when he decided to kill, the moment when he decided to walk for his gun. And you know that he decided to kill in that moment because he did grab his gun. He racked the slide. He switched the safety off, and he walked over to shoot Caitlyn. And you know that Caitlyn saw him as he picked up that gun, because he told you in his testimony, she was closer to it than he was. And you know because you heard that gun as it racked when Jill Terrio was showing it to you. You know Caitlyn heard the racking of that slide. And for what the defendant would admit to in his testimony yesterday, she at least tried to ask him what he was going to do with it. But he didn't answer, because within seconds, he had shot her in the head, and Caitlyn was dead on the sofa. The defendant shot and killed her without a second thought, and he never, not one time, said anything about Caitlyn being a threat or a danger to anyone in that moment, not until he took the stand yesterday. Compare that to his actions as he described them in that story about the burglar in Nevada, a story that defense puts to you in their closing as explaining why he didn't call the police when Caitlyn was in his house. But it does so much more than that. It shows you the difference in behavior that the defendant has, the restraint that he can show, the fact that his muscle memory isn't all that's to him. A stranger trying to break into his home received more consideration than the mother of his children. That stranger was told to leave. He told them to go. He called the police. The defendant warned the stranger that he was armed with a gun. He went to the length to open the door and show the stranger the gun. He sat and waited with his loaded gun while the stranger tried the door, tried the windows, tried to break in. His muscle memory didn't take over. He didn't just shoot. The defendant never fired. He didn't shoot. The stranger walked away unharmed. But the mother of his children, she had to die. You listened to his statement during the presentation of the case. You have it in evidence, and you can listen to it again as many times as you want. You'll have a laptop back there that hopefully has a working CD player. You can listen to it, you can rewind it, you can jump to spots you want to hear. You should watch it. You should compare it to the statements that the defendant has now given to you from the witness stand. When you watch it, watch his demeanor, his body language, his facial expressions. Listen to the places where he hesitates or doesn't really answer the question that he's asked. Listen to the places where he scoffs, laughs, or smiles as he provides information to the police about where the bullet struck the mother of his children. Listen to the information he gave the police and his reactions and behavior when this was still fresh in his mind, 16 hours later, when he hadn't reviewed any evidence against him, but instead was telling things as they had happened. Even then, much like the defendant spent 3 hours sitting on this witness stand talking about child custody and his life before children, as well as his love of his children, the defendant spent the first 40 minutes of that interview talking about those same things. Again, the defendant begins discussing the shooting about 40 minutes in and the reasoning for it about an hour in. He says that she was holding Elowen and refusing to leave. That's it, nothing else. Nowhere in the statement does he say that he acted because Caitlyn was using force to commit any crime, let alone a kidnapping or being about to commit a kidnapping. Nowhere in that statement does he say she was harming anyone or physically threatening anyone. Many of the statements that he made yesterday are not in the statement to police. He never told the police that night Caitlyn again demanded money from him or sell his car. He never told the police that he was concerned that Caitlyn could reach for a gun. He never told the police that Caitlyn put her foot on the table and tried to use that to push away from him. He never told the police that Elowen shrieked or yelled or cried out because she was being hurt. He never told the police that he taught Caitlyn to fire that gun. You know, the defendant told you that during his testimony that he wanted you to believe that he's adding this information because he was misunderstood. He wasn't misunderstood. His words weren't misinterpreted. He just never said these things. Not for a year and a half. He is adding these things to change your opinion of him and of his actions, to try to get away with murder. The defendant spoke with detectives about every bad thing he believes that Caitlyn Naffziger had ever done to him or concerning their children. Is there any doubt in your minds that if she had said all these things he added from the witness stand, that he wouldn't have included them for the police? He'd had 16 hours to figure out to portray her as the villain and himself as the victim. The defendant has testified about being a Marine and being a father. Both of these things are true. But a third thing is true. He murdered Caitlyn Naffziger. He killed her out of anger that she was questioning his plans, anger that she was remaining in his house and wasn't leaving like his plans said she would. You got to hear those 3 hours of testimony in which the defendant spoke about his history and his love of his children. You'll never hear Caitlyn Naffziger's history or about her love of being a mom, about her love for those same children she carried to term, her memories of their first years. You won't hear about Elowen's first Christmas when she was just 2 weeks old. All you got to hear was when Brenda Plamondon told you that Caitlyn was so loving and so happy to be a mom. You don't get to hear Caitlyn's story about those last moments of her life. She isn't here because the defendant killed her. The defendant killed her out of anger. He killed her because he wasn't going to lose power over her, he couldn't control her, and he wasn't going to swallow his pride again. The defendant is bigger and stronger and heavier than Caitlyn Naffziger. He talked with detectives about whether she'd ever been violent with him, and he told them he would never have registered it because she was so tiny. She couldn't hurt him if she tried. Not then, not ever. And one thing the defendant never said, not once, not during any statements with the police and not from the witness stand, is that Caitlyn never, ever hurt their children. There's no evidence that he even would try to say that. Now, the defendant wants you to believe that he shot this small, unarmed woman in defense of others, that this murder was justified, that he had no choice, that his use of force was somehow proportional, because the judge will explain to you that his use of force has to be proportionate to what he is responding to. The defendant wants you to believe that what he did was reasonable. He wants you to find that Caitlyn was committing or about to commit a kidnapping when he killed her, that she posed a danger when he killed her, and that this makes his killing valid, that he was right to shoot her in the head. All of this despite his clear testimony that he had shot and killed her just because she had hurt their child in the moment before the shot rang out. In order for you to find the defendant not guilty, in this case. You would have to find that he acted in defense of others, that he both actually and reasonably believed that the mother of his children was committing a kidnapping or attempting to commit a kidnapping in that moment. Again, the defendant himself testified that he had suspicions, but you cannot kill someone over suspicions. It's not an actual belief, and it is not reasonable. The defendant testified that Caitlyn was threatening to call the police, that she threatened to take the children, but you cannot kill someone over a threat. That is not reasonable and is not an actual belief. There's nothing in the defendant's statements to police or even his testimony that demonstrates that deadly force was necessary or proportionate to the reason that he said he fired. He was a Marine. He was trained in martial arts. She was unarmed. The defendant didn't use deadly force because he had no other choice. He shot an unarmed woman in the head. He murdered Caitlyn. You have an evidence States Exhibit 9A. So just blown up for the purpose of presentation. States Exhibit 9A shows you Caitlyn as the defendant left her in that living room. This is a photograph of a mother sitting snuggled under blankets on a sofa, who has one foot kicked up on a coffee table, who has no shoes, no weapons, and poses no danger. This is a woman who moments earlier had a child on her lap. Their child. Their child. This is not a woman who was committing or about to commit a kidnapping when she was shot in the head. This is a woman with no friends in Berlin, New Hampshire. No friends in the area. Her family, a 2.5-hour drive away. She had never been there before. She had no car, no bus ticket, no means to leave. The defendant's reasons for shooting Caitlyn had nothing to do with the kidnapping. He told you he shot and killed her because he believed that Elowen was being hurt. He described that Elowen was hurt during his efforts to take her from Caitlyn. He said Caitlyn hurt her by holding her too forcefully. A person cannot use deadly force to protect someone from being held too tightly by their mother. That's not reasonable. The defendant did not have an actual or a reasonable belief that Caitlyn was kidnapping or about to kidnap these children. There's no justification, no excuse. This is not a reasonable use of deadly force. The facts tell you that. The law tells you that. Your common sense tells you that. The defendant shot this unarmed woman in the head while she was sitting on a couch, wrapped in a pink unicorn blanket. He shot her because she refused to leave and was holding their daughter. This wasn't an accident. It wasn't self-defense. It wasn't to prevent a kidnapping. It was murder, and he knows it. And now, so do you. The time for excuses is over. Please find him guilty of all of these charges.
Okay, members of the jury, we're at the point where I am now going to provide my instructions to you. Once again, I do think under the circumstances of this case, I do think it's appropriate to take a brief break before I provide you with my instructions. So we'll be back at 11:35. You will hear my instructions. After that, you will be ready to deliberate. And until then, again, until you have my instructions, I instruct you not to discuss the case with anyone amongst yourselves. And if anyone does so, please report that to a bailiff. As soon as we're back, I'll complete my instructions to you. And at that point, you can deliberate. Thank you. Please rise with your all rise.
Oh, that was torture. But there were some questions, and I will go over them. I'm sorry, Kathy. I was just waiting for mouth to be done. She had a lot to talk about. Okay, so the first question Caitlyn it could have been from a long time. Oh, about the hair in the weapon. Caitlyn had 2 plane tickets to return to Minnesota. Yes, because, well, because she can carry on the baby and not have to pay for an extra ticket. So the extra ticket would have been for Elwyn. I'm assuming, correct? Okay. Prosecution wants you to believe this part, but not some of the other parts. She decides which part of Dustin's testimony is true or not. Well, like she said, let's hope the jury has brought their common sense, because we're going to need it in this one. And she says, oh, she's twisting words now. I don't like that. No, she really put on a good show. She did a really good job at putting on a show for us today. I feel that this is going to be a tough case for the jury. I don't think they're going to come back in 5 minutes. I don't think they're going to come back in 2 hours. I think that these people are going to honestly take their time and assess the situations, look at the evidence, and make an informed decision. I mean, they're supposed to have all the evidence that they need to make that informed decision. So let's hope that they do. I believe that they will. I'm trying to figure out how to do a poll, but I don't know how. Shout out to Long Crime for letting me stream these last few days. Also, don't forget to like, share, comment. Share out the stream, because apparently I didn't have any notifications. You only get 3 in 24 hours. And I think I've used those up for the next few days. So, my bad. So how long of a break? Kathy, did you hear how long of a break? If you're still here. If anyone on the jury has ever been in a relationship with a controlling and manipulating person, they may vote not guilty due to defense of others. And that's true. You have a right, period, to defend yourself or defend your child. If you didn't defend your child, I don't care if it was the mother, you had a right to defend that child. He felt she was in harm's way with the way Caitlyn was holding her. Let me mute this and go back on my TV and find out how long the break is. 11:35. I just heard it. So while the judge gives his instructions, I'll be here.
11:35. I just heard it.
Oh, hey,
So
you be quiet.
while the judge
But while the jury is deliberating, I'm gonna stay live. I don't know what y'all want to watch, but I can put up the parole hearings in the meantime while we wait for the verdict. I like to watch those, but I do have to get into the shower because I do have an appointment today. And then I have an appointment Thursday, but I think this should be over probably today or tomorrow. The bus is going to be here at, I don't know what time, 2:20 maybe. That's if I don't cancel it. I feel like canceling it. I don't feel like going. My ribs hurt. My body hurts. Oh, I just hurt. I would rather take a nap than a shower. But unfortunately, that's not how things roll. And my neurosurgeon says I need therapy to get the rotation back in my head, my neck. It just hurts. My neck hurts all the time. But I get through it. But yeah, so I'll put on the parole hearings. If you want to watch it, you can. If not, it'll be up here. I'm assuming the jury instructions will take about an hour, 45 minutes. I mean, it's not a long case. So there's not a lot of charges. I think there's 4? So not a lot to get through. I don't know what happened. I did not do that. I am not doing that. Oh no. Did I get booted? What happened? Oh no. Where did it go? I don't know what they're doing. Oh, okay. I didn't want y'all to think it was me. So they should be back in 2 minutes. I wish I could do a poll, but it would just be Kathy doing it. It still would be funny. Hey, don't forget to like, share, comment, and also please subscribe. So that way you will know when I go live or put out a short or put out a video or, you know. I'm thinking about doing that case out of Wisconsin. It looks like it would be a good one. The boyfriend murder trial. She was missing for like 18 days. And I guess the cops forgot to read the guy his Miranda warning. And the prosecutor, she came out of retirement just to try this case. But they couldn't figure out the manner or cause of death because her body was so, DC. And they've got interrogation videos in this. I watched some of the rundown of the trial. Maybe we'll look over it. Well, no, because I have to take a shower. Maybe we'll look over it for a few minutes when they are going to go to deliberate. We'll find some things on it, but it seems like it's a pretty interesting trial. Not that any trial should ever be interesting because it's a tragedy. They had been together for years, 20-some years. And this guy was talking to women from the Philippines, and he was saying how he's going to leave in the fall to go to the Philippines to see them. And sorry. And they finally found her body. He had to have therapy on his ankle or knee or something. And they had stopped at the store, the Quick Star. And this case is out of Wisconsin. And they stopped at the Quick Star. We have those here and around this area. And she had gotten some breakfast, and then they went over there. Well, they had lost contact on his phone for like 35 minutes. But like 18 days later, they found her remains behind this building, and the animals just tore her up, man. Just tore her up. So then during the process, he hadn't talked to his dad. He was talking to him like all the time. And it's just a wild case. But I think maybe we'll look over it. The rundown of the case while we wait for the jury to come back. Bad boyfriend. That's what it is. Bad boyfriend. Matthew Paul? Pale? Oh, they're back.
Okay, thank you. Please be seated. Members of the jury, At the beginning of the trial, I gave you some general instructions as to the law that applies to this case in order to give you some guidance as you considered the evidence in this case. We are now at the end of the case, so I will give you further instructions, and then you will retire to the jury deliberation room to decide your verdict. You will receive a written copy of these instructions when you are ready to deliberate. I'm going to repeat the instructions that I gave you at the outset because this trial has occurred over several days. Place no special emphasis on any of the instructions that I am repeating. I am repeating them only to remind you of my earlier instructions in the interest of being complete. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict, and you have to understand what to consider in deciding whether to believe a particular witness. These instructions, as I said, will explain the law as to these and other matters so that you can reach a fair and just verdict. It is up to you to decide the facts of the case. You and you alone are the judges of the facts. You must decide the facts solely from the evidence in this trial. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You are to decide the facts based only on the evidence, and the evidence in this case consists of the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been arrested and charged with a crime is not evidence of his guilt. In this case, the defendant was charged by means of a document called an indictment. An indictment is simply a way of giving the defendant notice of the accusations against him. This type of document is a formal way of accusing him of a crime in order to bring him to trial. In your deliberations, you must not consider the fact of the defendant's arrest, the indictment, or the fact that the defendant has been brought to stand trial as evidence of the defendant's guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge, and you should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. What the lawyers have said to you is not evidence. In their opening statements and their closing arguments, the lawyers discussed their view of the facts to help you understand the evidence from their point of view. But the lawyers are not witnesses in this matter, and therefore they cannot testify. Therefore, what they said to you is not evidence in the case. If the lawyers stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Also, if the lawyers stated the law differently from the law as I explain it to you in these instructions, then you must disregard what the lawyers have said about the law and follow my instructions. During the trial, the lawyers made objections. Lawyers are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Please do not hold it against either party if they made these objections, and sometimes these objections required bench conferences. If I sustained an objection and I excluded any evidence, you must not guess as to what the evidence might have been. If I ordered that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and I admitted certain evidence, then you must not give that evidence any special weight as a result of my ruling. I am not expressing views as to the importance of evidence when I make my rulings. I am merely applying the law, as is my duty. Throughout the trial, I must be fair and impartial, just as you are required to be. So if I said or did anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. You, and you alone, as I said, are the judges of the facts, and you decide the verdict. Beyond explaining what you must not consider, I'm going to describe what you can consider as evidence. You should consider the testimony of witnesses and any exhibits that may have been introduced as evidence. In other words, you should consider only the legally admissible evidence and reasonable inferences that you can draw from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. There are two ways for a party to prove a particular fact in the case, either through direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. In other words, circumstantial evidence is proof of a chain of facts and inferences that tend to prove whether the defendant is guilty or not guilty. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that when you enter the courthouse, it is cloudy outside. While you are in court, you see someone come into the building who is wearing rain boots, the person is soaking wet, and they are closing an umbrella. If you could actually look out the window and see for yourself that there is rain falling from the sky, that would be direct evidence that it is raining outside. In contrast, if you cannot see for yourself whether it is raining outside, you could consider the facts and circumstances of the person you observed entering the court with the rain boots and umbrella to determine whether it is raining outside. That is an example of circumstantial evidence. You should consider both types of evidence, direct and circumstantial evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. There is, however, a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of a charged offense, then in order to convict, you must find that the totality of the evidence as to those elements excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, I skipped a line. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you must decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must decide which witness to believe and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. Similarly, if only one witness provides direct evidence concerning an offense charged, then you must decide whether to believe that particular witness, considering the factors I have already outlined and any other considerations you would ordinarily use in deciding whether to believe a person based on your common sense and good judgment. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that is important, but the quality of the evidence. That is, how persuasive the evidence is to you. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's appearance, attitude, and behavior on the stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness said appears reasonable or unreasonable, whether what the witness said is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. The principles I have outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under both our state and federal constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent man, and you must consider him to be an innocent man until the state convinces you beyond a reasonable doubt that he is guilty. If, after all the evidence and arguments, you have a reasonable doubt as to whether the defendant committed any one or more elements of the offense, then you must find him not guilty. Ladies and gentlemen, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Members of the jury, you must consider all of the instructions I give you, regardless of any opinion you may have as to what the law ought to be. The law, as I explain it to you, is the law you must follow in reaching your verdict in this case. Remember, all of the instructions I have given you throughout the case should be considered as a whole. So do not single out any particular instruction for special emphasis. As I told you at the outset, you will have a complete written copy of these instructions to have with you in the deliberation room. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts. One, a criminal state of mind, and two, an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his state of mind was. The phrase state of mind refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. First, he must have had the required state of mind, and second, he must have physically acted to do something that is criminal. Unless a person both had the required mental state and acted to do something criminal, that person has not committed a crime. This means that if a person either did not have the required mental state, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember that the reason crimes are given different names is that each refers to either a different mental state, or a different act, or a different mental state and a different act. Many persons do not realize that sometimes the only reason two identical acts are given different names is that they refer to different mental states. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other one did so out of carelessness, they would not be guilty of the same crime because they had different mental states. Thus, you can see how both the act and the mental state can make a difference. I am now going to discuss the definitions of the crimes with which the defendant has been charged. At the beginning of the trial, You heard the clerk read the charges against the defendant. You will receive copies of each of these charges with you in the deliberation room. In Charge ID 223-7508C, the defendant is charged with the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted knowingly, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, knowing. Certain words in the definition need to be defined. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically desired or intended a particular result. What the state must prove is that the defendant was aware of the nature of his conduct or the circumstance under which he engaged in the conduct. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proved that the defendant acted knowingly. Evidence has been presented that the defendant acted in defense of another with respect to this charge. When there is some evidence of defense of another, the state must prove beyond a reasonable doubt that the defendant did not act in defense of another. If you have a reasonable doubt on any of the charges as to whether the defendant acted in defense of another, you must find the defendant not guilty as to that charge. In deciding whether the defendant acted in defense of another, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend a third person if, 1, he actually believed that the other person was committing or was about to commit the crime of kidnapping, and 2, even if the defendant actually believed that the other person was committing or was about to commit the crime of kidnapping, the defendant's belief must be reasonable. In other words, there must be reasonable grounds for the defendant to have believed at the time that the other person was committing or was about to commit the crime of kidnapping. The distinction between deadly and non-deadly force depends on the defendant's mental state. If the defendant had the purpose to cause death or serious bodily injury, or if the defendant knew he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used deadly force. Serious bodily injury means harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or function of any part of the body. If you find that the defendant purposely fired a firearm capable of causing serious bodily injury or death in the direction of another person, then you should find that the defendant used deadly force. Any other assault, confinement, or other action by the defendant is non-deadly force. Thus, if the defendant did not act with the purpose to cause death or serious bodily injury, and the defendant did not know he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used non-deadly force. The defendant must reasonably believe that the amount of force that he used was necessary for defense of another. A person is not permitted to use excessive force in defense of another, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there were reasonable grounds for his belief. In Charge ID 221-7221C, the defendant is charged with a different variant of the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, reckless. Certain words in the definition need to be defined. The term recklessly refers to the defendant's mental state. To prove second-degree murder reckless, the state must prove that the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life. A person acts recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that his or her conduct would cause a certain result. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from that conduct that a law-abiding person would observe in the situation. There are several components of a reckless mental state that the state must prove on this variant. They are: 1, the defendant was aware of a substantial and unjustifiable risk that his conduct would cause a particular result, and 2, the defendant consciously disregarded the risk. In other words, he elected to disregard the risk and take the chance that his conduct would cause a particular result. It is not enough for the state to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. And 3, from what the defendant knew of his circumstances, his disregard of the risk was a gross deviation from what a law-abiding person would have done under the circumstances. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. For a killing to be second-degree murder, the defendant must not simply act recklessly, but rather must act recklessly under circumstances showing an extreme indifference to the value of human life. This means something more than being merely aware of and consciously disregarding a substantial and unjustifiable risk of death. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. With regard to element 3, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. In Charge ID 221-7222C, the defendant is charged with the crime of reckless conduct with a deadly weapon. The definition of the crime of reckless conduct has 5 parts. The state must prove each part of the definitions beyond a reasonable doubt. Thus, the state must prove that 1, the defendant engaged in conduct that either placed or may have placed another person in danger of serious bodily injury, and 2, the defendant acted recklessly, 3, the defendant used a deadly weapon, and 4, the deadly weapon was a firearm, and 5, the defendant did not act in defense of another. Certain of these terms must be defined. Serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or of the function of any part of the body. The term recklessly has the same meaning as that set forth above. Deadly weapon means any firearm, knife, or other substance or thing which, in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. A firearm is not necessarily a deadly weapon. Whether the specific manner in which the defendant used the firearm and the circumstances surrounding that use rendered the firearm a deadly weapon is a factual issue for you to decide. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition as above. In Charge ID 221-7223C, the defendant is charged with the crime of endangering the welfare of a child. The definition of this crime has 5 parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove: 1, the defendant owed a duty of care, protection, or support to a child under 18 years of age, and 2, the defendant purposely violated that duty, and 3, in doing so, the defendant's action endangered the welfare of the child, and 4, the defendant acted knowingly with respect to the endangerment, and 5, the defendant did not act in defense of another. Certain of these terms must be defined or explained. The term purposely means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result, with respect to the duty that he owed to the child. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do the prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. Your determination as to whether the defendant acted purposely is with respect to the action he took relative to his duty of care, protection, or support, and not with respect to the effect of such action. The term welfare means general well-being in any respect. Endangerment means the act or an instance of putting someone or something in danger or exposure to peril or harm. To find endangerment, the state must prove that the defendant engaged in behavior creating an actual and significant risk of injury to the child's welfare. The term knowingly has the same meaning as that set forth above. Your determination as to whether the defendant acted knowingly is with respect to the effect of the actions he took toward the welfare of a child. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. Each of the charges against this defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the charges should not influence your verdict with respect to the other charges. In this case, the defendant is charged with 2 separate counts of second-degree murder. One indictment charges the defendant with second-degree murder under a theory of a knowing mental state, and the other indictment charges the defendant with second-degree murder under a theory of a reckless mental state. These indictments are presented on alternative theories of culpability. You will deliberate and reach a verdict on each indictment. You should evaluate all of the evidence and apply that evidence to each indictment. The fact that you may find the defendant guilty or not guilty on one indictment should not influence your verdict on the other indictment. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, expert witnesses, medical personnel, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Beyond witness testimony, you will also be provided with certain exhibits that were introduced by the parties and allowed by the court into evidence. The court notes that some of the exhibits are considered tangible or physical exhibits, specifically including a firearm that was introduced into evidence. A lock has been affixed to the firearm to ensure your safety. If you would like to examine either the firearm or the ammunition, please notify the bailiff and those exhibits will be brought to you. However, you will not be allowed to examine the firearm and the ammunition at the same time. Further, although you are allowed and encouraged to view and inspect these items, please take no action with respect to these exhibits or any of the other exhibits for that matter, which would in any way impair their ongoing use by the court as items of evidence. Members of the jury, the principles of law that I've given to you are intended to guide you in reaching a fair result in this case, which is important to both of the parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all of the evidence, you must make findings with respect to the charges that are before you. You must decide if the state has proven each of the elements of each of the charges beyond a reasonable doubt. In other words, if you have a reasonable doubt as to whether the state has proven any one or more of the elements of each of the offenses charged, you must find the defendant not guilty as to that charge. However, if you find that the state has proven all of the elements of any of the offenses charged beyond a reasonable doubt, then you should find the defendant guilty as to those charges. Let me remind you that a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. In other words, your verdict must be unanimous. All 12 jurors must agree that the state has proven each element of each of the charges beyond a reasonable doubt as to that charge. You may find the defendant guilty on one, more than one, all, or none of the charges. When you have arrived at your verdict, let the bailiff know and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. As your first order of business, you shall decide upon your foreperson, write the foreperson's name on a piece of paper, and notify the bailiff of your choice by handing the paper to the bailiff. Ladies and gentlemen, this case is important to both of the parties, the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement. If you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purposes of returning a verdict. If any question of law should arise during your deliberations, the foreperson should write that question out, sign it, hand it to the bailiff, and the question will be brought to me, and I will return it to you with an answer. If, however, your question is one of fact, then I will not be able to help you because, as I told you before, you and you alone are the sole judges of the facts, and therefore you must rely upon your collective memory to resolve a factual dispute. A verdict form has been prepared for your convenience, which contains spaces for you to check off whether you find the defendant guilty or not guilty on each of the charges. Once you have finished your deliberations, the foreperson will complete the verdict form, sign it where indicated, and then notify the court officer who will give the form to me. After I review it, I will return it to the foreperson, and you will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court. Thank you for your attention. I will now select 4 alternates. Members of the jury, under state law, we provide for alternates beyond the 12 required to deliberate in the event that something occurs during the course of the trial. And I will give further instructions about the alternates once I pick them, but that is the process we are about to undertake. Counsel, I have prepared the appropriate number of cubes, and I'm going to shake the cube, shake the jar. I'm going to not look at it, and I will select one. Then I will repeat that process. Any objection to that process, counsel?
No, Your Honor.
Okay. Juror number 1. Juror number 4. Juror number 2. And juror number 5. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for the alternates to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, including amongst yourselves. When the jury reaches a verdict, you will be returned to the courtroom to hear the verdict. I want to thank the alternates for your service, and in a moment when we recess, I would like to see the alternates briefly at the bench. The jury may now retire to the jury deliberation room. It will take a few minutes, but I will see to it that the evidence and a copy of these instructions are brought to you. Anything further, counsel?
Could we approach Your Honor briefly?
You all know I came here to say, sidebar lady, get over it. Oh, he looks like he is. Poor guy. I'm sorry. I don't know. I guess I feel bad for both. My God, every time I start talking, I cough.
The jury may retire to the deliberation room, and I will see the alternates at the bench, please. Thank you.
So what do you all think here? Man, this is a tough moment. A moment of truth. What we've been waiting for. Since last week. So when he's official, they show the seal, the state seal. Then we'll go over that case, Matthew out of Wisconsin, weirdo. And see what y'all think about it. You know, I like to do these, and I know I don't spend a lot of time talking, but I'm new at this, so I'm not sure what I can and can't say. And I don't want to get in trouble for saying something that I shouldn't have said. So it's hard for me, you know, because sometimes I talk too much. So I don't have a filter. Is the judge done talking to the jury? I hope they still get lunch. I think it's lunchtime there, isn't it? What time is it? 11:18. So 12:18 their time. Oh, good. I like that picture. I'd rather look at that picture than the seal.
Are you ready? You ready? Are you still on the record?
I'm still on.
Okay, counsel, please be seated.
That's somebody.
And just to confirm, Attorney Kennedy did make a request relative to the indictments. The monitor has prepared the indictments and has redacted all extraneous information. We certainly will have those available to counsel to inspect relative to the actual indictments themselves, and please take your time in doing so. Anything further at this point? We will be providing lunch for the jurors under the circumstances, depending upon the scheduling council can discuss with the clerk relative to scheduling and timing of lunch. Okay, anything further? Okay, if there's any issues relative to the indictments, it's done in the same fashion that we typically do for all cases. If there are any questions, we'll reconvene. Okay? Thank you. Court will be in recess.
All right, y'all. I'm nervous. I'm nervous for old dude. I'm nervous. So I'm trying to figure out. That's a banner, but I want to put. My dog has to go outside. She is just whining. But I want to change the color. The color of. Oh my God, I gotta get closer. I want to change the color because I want to put verdict watch. So when people know when they come in, but I don't know. Like I said, and then Leah knocked my mouse on the floor. Font, okay. All right, so. Let's make it big, bold letters. Oh my God. All because she knocked my... Okay, here we go. Yeah, I am so new to this. But the more I do it, the more familiar I'll get with things, like having to use this stuff. Okay, here, this is a good one. Oh! Apparently you have to be in advanced, so... Oh, well. So let's just keep it the same color. I am not paying StreamYard $1,000 a year for that. But no. Hell no. They crazy. Okay. Banners. Okay. Headline. Oh, I think it's the headline. Headline, maybe? Let's try that. Leah, why did you have to knock my thing off? Yes, we're going to go. Hold on. Oh my God. I got to get my mouse pad or my key or my mouse. It's hard to maneuver. No, you ain't going anywhere. You done dropped stuff on the floor. Oh my God, and it's way under there. Well, I can tell you why my phone's not charging. Oh my God. Oh, jeez. My phone's unplugged. So that's not even charging. My heating pad. Oh, wait, I plugged that in over there. Yeah. I'm having a rough one here. Okay, I just want to put verdict watch like everyone else does. How do you do it? Can you tell I'm getting upset? I even have sounds. They're really cool. Yes. I'm going to mute this for a second. Okay, so that's just gonna have to do. I wanted to do a timer, but I don't know. That's something on I don't even know where to begin to get that. But I have to take Leah out. So I will be back. I can put on parole hearings, or if you guys want to chit chat in the comment section for a couple minutes. Okay, well, yeah, Leah's needing to go, so I will put on, but I will keep this going on my phone so that way I know when they come back.
Your Aunt Judy Green and Janet White, another aunt, and they will be speaking on your behalf. We do have representing the victim here in Baton Rouge with us. We have Ms. Phyllis Howard, Kenneth Howard, Kathy Howard, and Glenn Howard. And for those who have indicated they want to speak, we'll be calling on them at the appropriate time. First, I'm going to read some identifying information into the record, and I ask you to confirm if that it's true or not. And then I'm going to turn it over to Mr. Freeman, seated to my far right. Your case has been assigned to him. You ready?
Yes, ma'am.
All right. So, Mr. Anderson, you are classified as a first felony offender. You were sentenced in July of 2016 in the 19th Judicial District, that's East Baton Rouge Parish, for a manslaughter conviction. You received an 18-year sentence. You also had a simple robbery. You received a 7-year sentence. So your parole eligibility date is March 12th, 2029, but you do have a mandatory release date, good time date, which precedes that. It's March 17, 2028. Is that information correct?
Yes, ma'am. It is.
Thank you. Mr. Freeman.
Okay, Mr. Anderson, first and foremost, so what are you seeking today? You want us to cut the 18-year sentence?
Yes, sir. I would like the overall, I'm asking for the overall date to be reduced and the time to spend on probation and parole to be affected.
Okay, before I ask you what you're doing to get yourself in there, why do you think you deserve for us to cut this time?
The change in my life, the things that have happened, basically, excuse me, the mannerisms in my life, I grew up in a lifestyle that responsibility and things of that nature. I grew up with witnessing how drugs affected a family and things, and I was involved in transport narcotics and things of that nature. And when it came down to taking care of the family, you did what was necessary and looked the other way. Kurt was my family. He was my brother. And the things that took place that day would never have taken place if it was not for my responsibility and the things that took place. I'm grateful for the board to even consider my opinion of why I should be released, because the opinion of the family weighs heavily upon me on why I should be released, because it is my family as well. The actions that took place that day did not only affect a random victim, but they affected my family, my entire family. And they see it as a lot of people have raised the concept that it was my stepbrother, but he was my brother in relation, not just by genealogy. He was my family. I put myself in position here, and I work with others with coming into the facility. I work in the law library. I came to jail as a early adult, 27 years old, illiterate. I graduated high school, but I was also in special needs because I was a dyslexic. I learned how to read in solitary confinement when I was in Elms, going through the medical facility from the car accident that I had, and I suffered brain trauma. As I learned how to read while I was sitting in there, I learned to take the importance of words and responsibilities. I've now put myself in position, and this facility has allowed me to. I study law, not only by God's law, but man's law as well. And I take that time to, one, teach a Bible study from the biblical literature that has taught me how to take responsibility and ownership for my actions, but also to how to be a leader and help others that are less fortunate than yourself. I take my free time on the weekends and during the week as an offender counsel to help others that do not understand the law, just like I did when I came in, of being ignorant to it. Ignorance is a choice. I chose to be ignorant of a lot of things in my life. No longer do I choose to remain that way. Stupidity cannot be helped. It is a mental condition. I don't suffer from that mental condition of stupidity. I chose to be ignorant of a lot of things in my life, which I no longer do. I take my time now, and I help new offenders coming into the facility. They come
Okay, they've got that. Tell me what you did to get yourself put in there. We've heard a lot of good things of why you should be out. What did you do to get yourself put in?
What I did not protect my brother like I should have. Over the lifestyle in which I grew up, my brother was shot. I was not in the room when he got shot, but I immediately conducted myself in to cover up what had taken place that day. I did remove the surveillance system, and I did dispose of the weapon that was used to kill my brother. The individuals that would have taken place that day, my wife at the time, Vincy and Ben, would never have been at that house. Growing up, I'm sorry. I brought them to that house to discuss things that had taken place earlier that day with my brother. And when they came there, yes, money and drugs were supposed to take place in the near future. And I believe what happened with my brother, because there wasn't any drugs or money to take advantage of or to rob or take, that's why I believe that is why my brother was killed. I do not know the exact reason of what took place because I wasn't in the room when it happened, but I know the lifestyle that I was living, that those types of individuals gravitate towards that, and I am responsible for bringing those individuals to my brother's house.
Okay. And how long have you been in jail?
I've been in jail 13 years.
10 years.
Okay, no.
Okay. Warden, what do you have to say about Mr. Anderson?
Well, I'll say that
throughout Ms. Anderson's incarceration, he has had a great disciplinary record. We have no disciplinary record on him at all. 0 disciplinary reports. He's achieved minimum custody. He's a trustee. He is a legal counsel substitute. He's completed Bible study college, completed legal aid training. He's been a participant in AANA, finished anger management, living in balance, various faith-based programs. He's pretty much done everything we could ask of him in prison. He's behaved as a model inmate, taking advantage of pretty much every kind of program we offered. So he's made the best of his time here.
Thank you, Warden. Appreciate that. Okay, now we're gonna get to the people that are here to speak on his behalf. Miss Judy Green, his aunt.
You're good. I'm sorry. Good morning. Thank you so much for giving us this opportunity to speak on behalf of our nephew. I'm not here to excuse what happened years ago. Richard himself would never ask us to excuse it. I'm here because I've seen the man he has become and the deep remorse he carries every single day for the choices that led him here. He made a decision early on in prison that his time would not be wasted. He pledged to God and himself that he would be a better person when he came out. He, like y'all said, he's reading the Bible, helping others. He works in the law library, is assisting other inmates in understanding their rights and legal options. He teaches classes based on the chosen. He has earned the highest level. Some of this is, I'm repeating, he has earned the highest level of trustee possible. He has told me, Aunt Judy, I cannot undo the pain I caused, but I can honor the life that was lost by living right, helping others, and being accountable. And that's what he's done. I mean, Richard is no longer the broken man he was when he made those choices. He is a mature, thoughtful, deeply spiritual man who knows what grace and responsibility mean. We believe Richard will continue to be a force of good, not inside prison walls, but out in the community. He has plans to continue monitoring others, working in faith-based programs, and using his knowledge to guide those who felt lost like he was. I believe in redemption. I've seen it in Richard, and I asked you today to see it also, to see that his time has not been wasted, that he truly has been rehabilitated, and that mercy in his case would not be misplaced. Thank you so much for listening. And I know this is difficult work for y'all. I know that granting clemency isn't something that y'all take lightly, but I believe with all my heart that Richard has earned a second chance. Thank you.
Thank you, ma'am, for speaking to us today. Okay, next we have Miss Janet White, also his aunt. I saw she doesn't wish
She
to
can't
speak.
talk. She's not going to talk.
Just say you're the spokesperson.
I'm the spokesperson for these people.
Okay, well, thank y'all. Okay, now we're gonna get to the opposition. We have here in opposition Phyllis Howard, victim's mother, Kenneth Howard, victim's father, Kathy Howard, victim's aunt, and here and not speaking will be Glenn Howard, victim's brother. So y'all decide who wants to go first, and let's see what y'all got to say.
I'm Kenny's brother. Is that what you said?
Sir?
I'm Kenny Howard's brother.
Yes, sir.
Okay, you said the victim's brother. I didn't know.
No, I did say the victim brother, but they had written down. Okay, Kenny's brother. Sorry about that.
That's all right. Thank you.
Good morning. Thank you for listening to me this morning. I listened to what Richard had to say, And, I'll give my own writing about it, the way I think. I'm very nervous this morning. I've been living at this for 15 years. Richard has a long record of having a manipulative personality. He's got a clever and skilled way that is deceptive and sneaky to achieve his goal. He has not changed. I spoke with him once when he called his mother. He doesn't understand the horrible situation of finding my child with a gunshot to the head. The fact that he planned the murder, he omitted that when he was speaking a while ago. He planned the murder of his stepbrother. All I heard coming out of his mouth when I spoke to him that day was him being the victim. He has played the victim part from day one. I know he and his mom were very close, but he commented several times about Kurt and his love for me. He has always been jealous of Kurt and oftentimes proclaimed it out loud. He doesn't like me because he knows I see through him and he can't manipulate me. I have been very vocal this whole time about this. I know he'll try to harm me in some way or another. That's why I think that he should serve his full term. 12 years for killing someone, and he thinks that he should get a free ride for the hell that he's put me through. I don't think so. The suffering that I've gone through is I'm still reliving it because I found Kurt with a gunshot to his head. And I'm on medications to try to sleep at night. My fear of safety, he will probably come after me. The lack of remorse, he has none, regardless of what he says. His unchanged nature, he will never be, well, he will always be a narcissist. That's the way I think, that I see him. And I'm sorry, this sounds mean, but that's what's in my heart right now. And I miss my son very much. Thank you for listening to me.
Thank you for coming. Okay, Mr. Kenneth Howard? Would you like to you want to go next? Go ahead.
Yes. Thank you for listening to me today. My name is Kathy Howard. I'm the aunt of the victim, Kurt Joseph Howard. I'm here today to tell you about a man who was a son, a grandson, a nephew, a cousin, and a friend. Kurt Joseph Howard was born on November the 19th, 1977, and his life was cut short on June the 4th, 2010 by Richard. Kurt was 32 years old. We all still are in mourning for his death. We miss his love, his presence, his voice. I miss his laugh. I miss hearing his voice when he would come through the door. He'd always say, "Hey, Kathy," and give me the biggest hug. You see, we live on the same street as Kurt. And my son and Kurt grew up together. So did my daughter. She was a little bit younger. They had more than a bond of cousins, but of best friends. This relationship carried over into adulthood, and as they remained close friends, it was the same with me. I see what Kurt's death has done to my children. I see what it's done to all of us. I see my brother rising every morning with the knowledge of his son is no longer here. I hear it in his mother's voice when we talk on the phone. I saw it in my departed mother's eyes as she would remember Kurt. Kurt was has missed out on experiencing those wonderful adult milestones in life. To watch him marry, to watch him have children and grandchildren, to add to the lineage of the family. But that's not going to happen. Kurt was a generous soul, even beyond death, as he was an organ donor. He changed people's lives. Kurt was funny, loyal, giving in every way. He was a wonderful nephew and he was a good guy. All of this was taken away by the actions of Richard Anderson for reasons I can only speculate. Jealousy, vindictiveness, but it was ultimate betrayal. This was premeditated. Not only did Richard hire a hitman, but he brought the guy to Kurt's house. He made sure he got in the door. This is truly the ultimate betrayal. Once Kurt was inside, he was made to kneel on the floor. The shooter put the gun to the back of Kurt's head and he pulled the trigger. As Kurt lay dying on the living room floor of my mother's house, Richard went into the bedroom closet where the security recording equipment was, and he stole it to make sure that no one would see his actions. And in an instant, our lives were changed forever. Richard even went a step further by stripping Kurt's jewelry off of his dying body. Yeah, he took that Rolex to the pawn shop. We never found his ring or his necklace. Richard does not deserve clemency. He doesn't deserve a pardon or parole. He should serve every day that the law will allow. I ask that the board deny Richard Anderson's request. In closing, all the family has suffered, all of the friends. Fear of safety? I don't know. Lack of remorse? I hear what he says. Only time will tell if that's time needs to be spent in prison. And his nature is unchanged. He's always been a manipulator. Sometimes his thoughts just don't change. I appreciate you and I thank you for hearing me.
Thank you. Okay, now we'll have, Mr. Kenneth.
Thank y'all. Kurt was my only son. He was my only child. Ever since that day, I just, sometimes I can't function. I'm a strong, big man, but I love Kurt so much. He would call me on the phone. He would say, "Hey, Daddy." I'll never get a chance to hear that again. I took him on all the jobs, self-employed. I want to take him all the time, be stick with me. And what you've heard from Richard, he didn't tell you that he's the one that gave the gun to Ben Morgan. He didn't tell you that his wife paid Ben Morgan $1,000. He won't tell you all that. I think he's doing real good right now. I really do. And I think he ought to stay right where he is and keep doing it. Because he's made life miserable for me, for his mom, my brother and sisters, nieces and nephews. I take Christian medicine. I have to take medicine to sleep at night. I just miss him so much. And then somebody tell you, it'll get better, or, I hope nobody ever has to lose a child. That's the worst thing in the world, having to bury a child. But I wouldn't wish that on nobody. So, Thank y'all for listening to me.
Appreciate you coming very much. Okay, I was giving you case, Mr. Anderson, so I'm gonna lead with the question and I'm gonna say something that I heard from two of the victims. You were the mastermind. So how can you sit there and tell us that you was in the back room, you didn't know they were gonna kill him? When you were the mastermind of the whole plot?
Sir, every one of you have a right to your opinion. I did not mastermind the hurt and death of my brother. My brother deserves to be honored along with his father, Mr. Kenny. That man has shown great mercy upon my whole family.
Okay,
I'm sorry.
that's okay. I've read the case, I've been over, you've served 13 years of 18-year sentence, and you have a good time date. I have no further questions, Mr. Marks.
All right, thank you.
I have no
Any questions? All right, Mr. Anderson, I don't see any other questions. I do believe we're prepared to vote, and I'll ask Mr. Freeman.
Yeah, Mr. Anderson, I don't know why you were given an 18-year sentence, but that is a mighty light sentence for what has happened here. You served 13 of 18 years. You have strong law enforcement opposition, strong victim opposition. My vote is to deny.
Mr. Tillis?
I concur with Mr. Freeman.
Stapleton? I concur with Mr. Freeman, and I'd like to mention to the family, I don't know if you may have been told already about Parents of Murdered Children, an national organization in America. But if you haven't, it's a good organization you can call, and it's Parents of Murdered Children. And it's a very good support system. And when you pick up that phone, they are just like you, and that's very hard to find. And I've been with parents when they murdered child donated their organs, and it is the saddest moment. So I'm very sorry for everything you've gone through, and my vote today is to deny. Mr. Craig?
I concur with Mr. Freeman.
All right, Mr. Anderson, I do, my vote also is to deny based on the proximity of your good time release date. So today, your application for commutation of your sentence has been denied, so.
Thank y'all.
Pardon, I think that concludes our business at your facility. We're going to sign off at 11:55. Thank you, sir.
Oh, well, that was too bad. Don't do the crime if you don't have the time. And he's got time. He's got time to do those 13, 14, 15, 16, 17, 5 more years. I wonder which one's next. Oh. Is it this one? Ricky Portales. And by the way, I just have an update on the shutdown. The Senate had failed to come to a conclusion to extend the spending bill to November 21st. So if you were in hopes of that passing today, that's a big fat no. It is going to affect, I just wonder what the stores are going to look like come November 1st. 14 million children are on the food stamp program. Now think about that. 14 million. This is the second time this has been a shutdown. I'm not going to get into politics, but I won't mention any names. Anyway, while we're waiting for the next hearing, because that one was a little sad. I do gotta start getting ready to go to my appointment. Oh, hold on.
All right, the Pardon Board is reconvening virtually now at the Capitol Oaks Nursing Center. And we have Mr. Ricky Portales in front of us. Mr. Portales, we've been advised, is nonverbal. So we have assisting us parole agent Kathy Henry. Ms. Henry, are you there?
Still what?
Your system's on mute. Can you unmute for us? Now at the Capitol Oaks Nursing Center. It's Mr. Ricky Portales. And Mr. Portales, we've been advised, is nonverbal. So we have assisting us parole agent Kathy Henry. Ms. Henry, are you there?
Yes, I am.
And you'll need to, we hear the YouTube on in the background somewhere.
Okay. Okay.
Yeah, thank you. We appreciate you taking the time to be with us today so you can assist us here. So I'm going to read some identifying information into the record. And Ms. Henry, I'd like you to confirm that this is the Ricky Portales that I am referring to. So we have before us Ricky Portales. His DOC number is 115004. As I mentioned, he's currently residing at the Capitol Oaks Nursing Center. He was convicted in Lafayette Parish in May 1986 for second-degree murder and is serving a life sentence. Ms. Henry, is this Mr. Portales in front of us?
Yes, ma'am, it is.
Thank you very much. Now, Mr. Portales submitted a couple of years ago a request for a commutation of his life sentence. Since that application was submitted and processed, Mr. Portales' circumstances have changed. Prior to this hearing, Mr. Portales was recommended by the DOC and approved by the parole board for a medical treatment furlough. Thus, that's why he is residing at the nursing home facility, nursing center. From my perspective, I'll just say that because August 13th, 2025, he was placed in medical treatment furlough status, I am not inclined to give Mr. Portales any further relief based on his record and the excellent care that he is currently receiving. So I will defer to my colleagues to see if there are any questions. No questions. Ms. Henry, is there anything you would like to add for us? Ms. Henry? I guess you're probably on mute.
Oh, my God.
There you go. Is there anything you would like to add for us?
No, ma'am, there isn't.
Okay. And are you his parole officer?
Yes, ma'am, I've supervised him for 1 month.
Okay, good. Well, thank you. And everything's going okay at the nursing center?
Yes, it is.
All right, thank you. All right, I am prepared to vote. My vote's going to be to deny his application for clemency because of his medical treatment furlough status. Mr. Tillis?
I concur with Ms. Renata.
Mrs. Stapleton?
I concur, Ms. Renata.
Mr. Prater?
I concur.
Mr. Freeman?
I concur.
All right, well, Mr. Portales, your application for clemency's been denied. It seems as though you're doing just fine where you are and you have the opportunity to visit for family. So we're going to sign off now. It is 12:04.
Oh, that one was quick. I'd have to say, I'd probably want to say, if he's got medical issues, why would he want not to be in the nursing home? I was wondering why it said nursing home. So I wonder if there's like a special ward where he's like behind locked doors, or does his door get locked, or what? I mean, he looks pretty like he ain't going anywhere. So the seal is still up, y'all. They're still deliberating. I know it's only been like an hour. Not even an hour. I think they went at 3:25. So they got a lot of parole hearings. They got pardon. Wow, he's been in prison for a long time. They say 1986 or 1996. I think 86. 86, 96, 2006. Well, he's only been there 20 years. Oh, wait. No. 86. Jeez. Hello. Math magician over here. Okay, so if it's been since 1996. 29 years. So if we add the 26, it'd be 30 years he's done. And that's on a second degree. So, I mean, I thought second degree, well, I guess he's got life though on a second degree. I mean, where did he think he was going to go? He was going to be at the nursing home. He has family that can come visit him. He doesn't really need to be anywhere else. I mean, he's not even in prison. I just stay where I'm at. Y'all, I'm about over this cough for real. It's like I'm not really sick. I just have a lot of like stuff from my nose. And I'm just tired of being sick. I had COVID, then I got this. Well, geez, how long are they going to take? Oh, here's the next one. Rosalind Rhodes.
Introduce yourself and tell us your name and your current mailing address.
My name is Benjamin Rhodes, divided 306 Acadian Lake Drive, Newtown, Louisiana, 7052.
All right, sir. And let me just acknowledge you have some folks here with you. Thomas Walker and Adam Leday. On Zoom, we have Ms. Rosalind Rhodes, all who want to speak on your behalf. Also on Zoom, Shanair Burnett and Deidre King. We do have representing the DA's office in Rapides Parish with us today, Mr. Johnson, who's also on Zoom and wishing to speak, and we'll ask him to do so at the appropriate time. First, Mr. Rhodes, let me just read some identifying information into the record and ask you to confirm it. I'm going to turn it over to Mr. Prater after that because your case has been assigned to him. Okay. So, Mr. Rhodes, you are classified as a first felony offender. You're seeking a pardon with restoration of firearms. You were sentenced in Rapides Parish in August of 2002, 2 counts of simple robbery. You received 7 years on each count, and they were to run concurrent. Is that information correct?
Yes, sir.
All right. Mr. Craig.
Okay. Good afternoon. Yes, it is afternoon. Good afternoon to all of y'all. Appreciate you being here, and we'll make this as quick as we can. First off, I want to hear from you and tell me what's changed since then, because you were pretty bad back then. Did some bad things, and now you're wanting. What exactly are you wanting?
I'm looking for, just as she stated, to have a taste of the story. First, I want to say thank you for allowing me to be here for you to have this. Appreciate the opportunity. Thank you for all. A lot has changed. She stated this was back in, the arrest was actually in 2001, 20-something years ago. Since then, my life has completely turned around from what I once was. Back in that time when I committed that crime, I was an adolescent that didn't think beyond goal. And I got engaged in a lot of things. I lived a lifestyle and had a mindset that brought me to those kind of consequences and other things that I faced during that time in my life. Since then, my life has been converted. I'm now a minister in a ministry that I've been a part of for over 15 years. I'm the regional director in Louisiana of an outreach organization that actually goes out to target those youth and those adolescents that were just as I once was, to try to deter them from the life and mindset that I once had. We've had a great success rate over the years. We've seen many lives impacted and changed by the efforts that we give in this outreach organization that I'm a part of. And that's my goal, to continue to reach as many as I can throughout all of this country, in the United States and beyond, with the lifestyle that I once lived, being able to relate to those that are there, being able to identify the mindset that they have, and also to give them the answer on how to make the transition. So many people that I've come across throughout the years that I preach to, minister to on college campuses, in the jails that I actually did time in before, on the streets, in rehabs, and nursing homes, so many gravitate to what they see in the word that they hear us minister. But the one question they have is, how did you make the transition? How did you go from being this person, having this mindset, being addicted to these kind of things and this kind of lifestyle, to what we see today? Some people, many people that see me today are marvel and never have an idea or clue that I come from the lifestyle and background that I have. The thing that I tell them is that I had a mind change. I've gone through jail. That brought some kind of conviction within my mind, a fear to not want to ever go back to jail. I've gone through deaths in my family that kind of shook me up. I've gone through consequences for the life that I lived that at some point shook me up. But the only thing that changed me, the only thing that caused me to be different, is having the Word of God minister to me and allowing those principles, those ways of reasoning and thinking to get inside of my mind. That caused me to see things different. And that's been since the summer of 2010. I've never had a mindset. I've never had a mind battle to go backwards. I never missed the old lifestyle of the things that I was once engaged in. I don't suffer with temptations or provocations from things that I was once so accustomed to. People marvel at that, but that's what done it for me. That's what brought about the transition and the sustainability of what you see today. And so my objective in obtaining my rights back, of course I would love to hunt. I'm in a ministry that's filled with many hunters. I've never been able to go for obvious reasons. I would love that opportunity to be able to, when we meet people, oftentimes we have to spend a lot of time with them, mentorship type ways, because a person left to themselves, they still in the same society, they still in the same world, so the temptation will not come. One thing that helped me is being connected with people that I'm a part of. One of the support that's here for me is my pastor. Somebody that when I initially came to this ministry that I'm a part of, I came as I was. I would go to his office throughout the day, and I would stay there hours every single day because I wanted change. I wanted to be different. I was tired of the way that I was, but I didn't know any other way of living, and I didn't know how to make that transition. Being connected with those that have been converted, that have obtained what I was searching for, it gave me strength. It gave me durability. When we meet people today throughout Texas and Louisiana and anywhere that I travel, we like to stay connected with them. We take them out to eat, bring them to our homes, bring them into our circle. Added thing that some are able to do that I'm not is to go out hunting with them. That's something I would love to do. Also with my family, my children. The other part, my other objective is being able to have that full testimony that God restored it all for me. I've gone from being the person that I was to being married almost as long as I've been married. I've been married, going on 15 years. Is it 15 years? I've been married about that long. We've been together 16 years. I know that much. But being able to say, I've gone from that lifestyle to being a faithful husband, to being a law-abiding citizen, to never going back to drugs and drinking or back to jail or any of these things. It's something that's amazing to me to go back into the jails where I once wore the same orange jumpsuit, zebra suits, and be able to minister to these men, be able to let them know I've been where you are, but there's hope. If you have the mind to do the same thing that it took for all of us to make this transition to do. Being able to add to that God actually restored everything to me and there's no restrictions. So that someone can see that not only will God and His Word, when you're allowed to take deep root inside your conscience, not only will it change you to be a better person and open up some doors for you, you can actually go on in life and out in society without any restrictions because you do it the right way.
Okay,
I'm saying that change.
It's rolled up. Let me slow you down. Sometimes when we get preachers up here, we have to kind of rein them in because we got a lot of folks want to talk on your behalf, and so we need to move on. Then we're going to come back and ask you questions. So you're not through. You know, we're not through talking to you, but we want to move on.
Yes,
That's
sir.
okay. Okay, let's talk to, we got 3 people on Zoom. Well, we got 1 at Zoom, that's your wife, and then we got 2 at headquarters that are gonna speak. And then we got some a church leader or 2, Miss Burnett and Miss King. And, so they're not gonna speak, but they're on Zoom. So we'll let y'all decide which of the ones here are gonna go first, and then we'll talk to the wife last, okay? So, which of you fellas would like to go first? Would you introduce yourself, please, sir, and kind of limit your remarks to a couple minutes, if you would?
I'm Adam Leday, the executive administrative pastor of Bethlehem Ministry of Lafayette, Louisiana campus. And everything that Benjamin Rose has stated, I've been born again Christian over 40-something years. I've been pastoring for over 20 years. And through the word of God and the power of God, to see the transformation this young man, like as he had stated, I wasn't there to see his past, as I heard his testimonies. He got pictures, he showed, the rest says we know, but to see how when he came into the ministry, he embraced the word of God and allowed that word of God to change his life. I'm an eyewitness that, as he stated many times, he was in my office on a daily basis. He wanted to know what he had gotten into and how to go about with the word of God. And definitely, his commitment to the word of God has really transformed his life. I've seen thousands and thousands of people come and go, but he has been a young man that have embraced, that's what it is, you have to embrace that word of God. You got to believe it in the principles and it work. You can't play with it. You determine that you want to do what it says, and it works. And I'm an eyewitness to see it work in his life. His life wasn't my life. I was born up in a Christian family. I've never been in the trouble, but I witnessed people that come lifestyles and see how, again, when they embrace the word of God, God definitely can change their life. Definitely eyewitness, and I can validate everything that he said. Thank you.
Thank you, sir. Appreciate that. We really do. Okay, next up.
I'm Thomas Walker. I'm also Sergeant Walker at the Lafayette Parish Sheriff's Office. I've been on Mr. Benjamin Road for a very long time. I've seen his transformation. I've seen people come, what my profession over going on 18 years. I've seen a lot of people say a lot of things, and they don't change. But I have seen his life change dramatically. And it's been through the word of God. It's been through not him just saying something, but he's done it in his life. And he's not only doing it for him, he's doing it for other people. He's helping other people change. So when you see a person not only change their life, but able to have the impact to change others, that speaks volumes. That speaks volumes. So I'm just saying that as not only a sergeant, but as a friend to me, because I've seen it in his life. I work with him on highways and hedges when we go out in the communities and we do these events to help other people. And I see him operate flawlessly. So I just wanted to, everything that he says, I can testify to it.
Thank you, sir. Appreciate those words.
Yes, sir.
Now we'll go to Zoom and we'll talk to your lovely wife, and see what she got to say.
Hello, everybody.
Hi there.
Hi, my name is Rosalind Rhodes, and I stand here today with the heart overflowing, thanking you all, and with gratitude and humility and joy as I speak on behalf of my husband, Benjamin Rhodes. Today is not just about a pardon, it's about a life redeemed, a soul restored, and an incredible power of God's grace. My husband's journey has not been an easy one, but it has been one of transformation through faith, discipline, and unwavering service. There was a time when his past choices defined him, but through his commitment to God, he made the decision to let go of the man he used to be and become the man God always called him to be. He has devoted his life to serving others, mentoring, volunteering, and giving back to the very communities that once saw his struggles. He has become a living testimony that change is not only possible, it's real, it's visible, and it's lasting. Through years of reflection, accountability, and faith, he has allowed God to completely transform his life. He has faced his past head on, not with excuses, but with a sincere desire to make amends and live differently. In his journey, he has found purpose in service. He has become fully devoted to helping others, working tirelessly and uplift his community, whether by mentoring those struggling with addiction, volunteering in outreach programs, or simply being a voice of encouragement and compassion to those who feel forgotten. What stands out most about Benjamin is his humility. He doesn't serve for recognition or reward. He serves because he knows what it means to be given another chance at life. His faith has become his foundation, and his daily actions are proof of a heart transformed. Today, I don't just see a man who has changed. I see a man who inspires change in others. He has shown that redemption isn't just possible, it's real and it's powerful. I humbly ask that you see the man he is today, the man who has surrendered his life to God, devoted himself to serving others, and continues to live every day with integrity, compassion, and purpose. Thank you for your time, and thank you all. Have a blessed rest of your day.
Thank you. I appreciate that. We'll consider those words also. We'll move on now to the Rapides DA's office. Mr. Derek Johnson, are you on Zoom, Mr. Johnson?
Yes, I am. Thank you, the board. The Office of Philip Terrell still opposes the pardon with restoration of gun rights, even though the conviction was amended to a simple burglary. The original charge was still armed robbery, which is a violent offense involving the use of a threatening weapon. And while we respect the applicant's transformation and his service as a minister, the original conduct and public safety implications and the purpose of firearm restrictions all weigh against restoring gun rights. So we are still opposed to pardon with gun rights. Thank you.
Thank you, sir. We appreciate your comment. We'll take those into consideration also. Mr. Floach, would you stand back up there and let us badger you a little bit now? I'm the first one gets to, and then the rest of the board gets to, and then we vote, is the way that it works, okay? Yes, sir. How old were you when these robberies occurred that you pled later to simple robbery too?
18 years old.
You were 18,
Yes.
and how old were the people that were with you?
Don't remember exactly, but they were older than me. I must say one was maybe in his 40s, the oldest one. The other one was somewhere close to that. I was 18.
Did you say 40?
He was like 40 something years old.
But they were a good bit older than you, huh?
Yes, they were actually people that I looked up to growing up.
Okay, and you're asking for us to pardon you on those two simple robberies, correct? Okay, well, let's move forward now. This is what troubles me more than even that, and you know where I'm going. In 2008, you were charged with a second-degree murder in possession of firearm by a convicted felon. And I know you said your transformation didn't place, and I'm glad you said 2010, because I was about to say, well, you didn't completely transform, but you were honest with that, and I appreciate that. Tell me, even though the murder charge was dropped, I got to know about it to satisfy myself and my vote. Tell me just roughly what happened there.
June 15, 2008, Father's Day. My mom was at home. I went to my mom's house. She had just bought a house and met her and my stepfather. I went there to tell my mother and my stepfather that I was Father's Day. My dad was stressed out across at my stepfather. I called him my dad, but he was stressed out across the bed, still had his clothes on from the night before, hungover. I spoke with my mom's, I left, I came back, my stepfather was woke, and we began to get drunk that morning for Father's Day. I remember we was drinking Crown Raw. And we was putting up the screen door, and it seemed like everything was fine. But my mom and stepfather got into a verbal altercation. Wasn't nothing new. I had seen this all my life. I grew up living the life that I lived, pattern all of my stepfather, except for the fact that my stepfather was abusive to my mother. I seen my mother throughout the years, black eyes, lust lips, abused, cheated on, you name it, I seen it. I was a witness of it. So this wasn't really new. I just was grateful that it seemed as if it wasn't going to be physical, so I thought. But it actually turned out that way. My mom had just had some kind of surgery procedure where she wasn't 100% physically. And so they get into this verbal altercation. Myself, my cousins, and my nephew, we all go outside because my dad, my stepfather's packing his things, leaving. In the process of that, I noticed that the windows were down on my mother's truck. So I'm going back into the house to get the keys to the truck to put the windows up. And I remember like it was yesterday, I pulled the screen door to open it, and I heard screams that haunted me for years. My mother screaming my name, sounding like a man. Ben, Ben, Ben. So I run through the house and I come around to their room door, and my stepfather's on top of my mother, choking her out with a 30-day special, ready to shoot in her face. I said, all I remember saying was, man, what are you doing? And it's like he was ignoring me, and I didn't know it at the time, but my mom actually lost consciousness. I didn't know that some years ago. Long story short, I ended up pulling out the gun that I had, and I began to fire round after round into my stepfather. One of the bullets, after the shooting stopped, my mother regained conscience. She pushed him off of her, and she slid between the bed and the dresser that was in the room. And I checked my dad to make sure he's not finna get up and start shooting with that gun, but he's completely cool. And all I hear is my mother behind me saying, Ben, I'm shot. And I turned around, one of the bullets actually went through my stepfather and struck my mother in the leg. And so doctors thought my mother would never walk again. They couldn't get the bullet out. My mother's alive and well today. And she's actually one of the first faces that you see when you visit our church. She's the woman, one of the women that swings the door up and says, welcome to Refuge Temple Ministries. I called the police. My cousin and nephew came running in the room, and I tell my mom, I cannot stay. I had just got out of jail. I got out of jail September 21st, 07. I got off parole May 08. This is June 08. And so I'm like, this is crazy. There's no self-defense law reason. There's no explaining this. So initially I ran. But I stayed in touch, contact with the family. My stepfather's dead. I'm totally in my mind. My mother can't walk. She's in ICU. My cousin talked me into turning myself in. So I go back to Lafayette. This happened in Lafayette.
Y'all, I'm here. I'm just listening. I like to hear if people are going to get out or not. just listening to their story.
I got my car in Baton Rouge. I went to Monroe for a while, and then I came back to Lafayette to turn myself in. My mom was the only witness in the room. She gave the story, told me what happened. My neighbor across the street that seen me when I fled the scene, she gave her statement. When I turned myself in, I told them the exact same thing that I just told you, that I killed my stepfather, and this is why. And I suffered a lot. My mom suffered, my family suffered a lot behind that, because this wasn't a man that I had problems with or anger issues with. Growing up, me and my dad were the closest of closest, him and my family was, I tell you that. So this was heartbreak. This was real trauma. And it took me some years to get over. My pastor helped me with that throughout the years. But that was the situation. And in retrospect, if I could rewind the hand of time, I always tell people I had no other choice in the matter. The only option that I had at that moment would have caused my mom her life, and more than likely my own. I don't believe my dad was going to shoot and kill my mother and walk past me standing there. And so I always tell people I had no choice. It was either defend my mother and take my dad's life, or my dad was going to kill my mother. But I tell people today, looking back retrospectively, knowing what I know now, what could I have done to prevent that entire situation? And I know now. When I was in jail for those robbery charges, I was converted. I started living for Jesus Christ. Some people call it jailhouse religion. It was real to me. I did turn away from it. And that was the biggest mistake I ever made in my life. Because had I not turned away from God then, I would have never been in that position in the first place. And so now I know the best thing a person, in my opinion, can do is continue to live for Jesus Christ, and they will avoid all the troubles of life that can result from things like that.
And the DA chose not to prosecute that and agreed with you that it was, is that correct?
Yes.
Okay, so that wasn't ever pursued, and although you were charged with it, it was dropped, and that was not part of the deal. But you pled guilty to illegal carrying of a weapon.
Yes.
But you weren't supposed to have that weapon anyway, because you were charged with felon in possession. So you pled down. So I say all that to determine, because it's really two things here. You want the pardon for the robberies that occurred, and I don't have a big problem with that personally. I do have a problem with the firearm though, and granting the firearm, and so I'm trying to get to the bottom of that. But that's all the questions I have, Madam Chairman.
Any other questions? No other questions, so Mr. Prater, you're ready to vote.
Okay, forgive me, Ms. Rhodes, but I'm gonna vote to pardon you for the charges so that you can say you're not a felon and you pardoned from all that business, but I can't in good conscience vote to give your firearm back. So my vote is to pardon without restoration of firearms.
Mr. Freeman?
My vote is gonna have to be the same also. You're doing great. Appreciate everything you're doing, but, pardon without firearms.
Mr. Tillis?
I concur with Mr. Prater.
Mrs. Stapleton?
I concur with Mr. Prater.
All right, you got 4 live votes for the pardon without restoration of firearms, so that is the recommendation we're gonna make on your behalf. Now, you can, if you're successful with the governor, at a later date, you can come back and, seek the firearms back. Good luck to you.
Thank you so much.
All right, y'all. So I wanted to go over that case that I was talking about earlier. The one in Wisconsin that's going on right now. Oops, I just opened up a new tab. Damn it. So I'm really shaky. I just did a breathing treatment and my whole body's shaking. Where did that go? Right here. It's called Bad Boyfriend. And let me move him over. so I can put it on. Oops. It's called Bad Boyfriend, and it's actually a very strange case. And there you go. I shared it. It's just taking a second. Okay. So, Waukesha, or however you pronounce it, a Wisconsin man is standing trial on charges that he murdered his longtime girlfriend, whose body was found decomposing in the woods. Matthew Paul is charged with first-degree intentional homicide and hiding a corpse in the death of Stephanie Pavlons, identified as Victim A in court documents. The victim in the case was last seen on August 23rd, 2022, leaving the apartment she shared with the defendant. The victim's parents told police that the couple lived together and had been in a turbulent on and off relationship for 20 years. The victim's mother said she suspected her daughter was a victim of domestic abuse in the relationship. The victim's body was found badly decomposed in the woods by a group of construction workers who were posting no trespassing signs in the area. The body was so badly decomposed that the medical examiner was unable to determine the cause or manner of, and police said surveillance video from their apartment complex shows them both leaving on August 23rd, but only him returning with her purse and water bottle. Police who searched Paul's cell phone found that he had been communicating with 2 Skype accounts, Majin and Beautiful Disaster. The conversations were actual in nature, and in messages with both accounts, Paul said that he wanted to move to the Philippines. So day 2 of the trial coverage, according to Court TV, credit to Court TV. I will put their link in the description. Georgian Pavilions, the victim's mother, took the stand. Stephanie was one of 3 children and was in a long-term relationship with Matt. Oh, we're not going to read that, because if we watch the case, then we can hear. So they have day 1, day 2. The defense said no proof Matthew Paul, ill girlfriend found dead in woods. I thought maybe there might be a video for us to watch. So that's pretty much a rough rundown of what it is. Let's see if, oh, we don't want to watch the, do you think they'll play the Matthew? I don't want to watch the trial live because I don't want to get started on the case until we've officially finished this one. This is the man, Matthew Paul. So this is this morning. Rebecca Harrow was in court. His schedule is November 3rd. So I don't know which one I'm going to do. If I'm going to do the Matthew, the bad boyfriend, or I'm not sure which ones are coming out. I know there's that beauty queen one where she illed her boyfriend's son. That's really sad. You know, they've been at it now for almost an hour and a half. I don't know what else to keep doing. I don't know if I should just come back when there's a verdict, or do we stay on? What do we do? I don't know. I guess we can watch this other parole hearing.
Oh, I'm at Hoop Container in St. Francis Hill. That's the old big mill.
Okay, and how long have you been out there?
Just past the 10-year mark.
Good, good.
Yes.
Okay. So pretty much about the time all this happened is when you went to work out there.
Yes, sir.
Okay, well, that was a blessing. Okay, and tell us, why do you want a pardon?
I mean, the biggest thing is holding me back in my career. I can't really go work where I want to, with this on my shoulder, on my name. And I really like my guns back. That'd be nice to enjoy hunting season like I can, like I want to. The main thing is holding me back in my career. Can't go work where I want to with this on my name.
Okay. And have you ever been arrested since then?
No, sir. Okay. Only time I've ever been.
That's the only arrest on your record?
Yes, sir.
Okay, and I also want to note for the record that Tony Clayton is unopposed. The chief is unopposed in Iberville. The chief in New Roads is unopposed. Both sheriffs did voice opposition. But other than that, I have no questions.
Any questions? I don't. Have you ever been turned down a position because of the felony on your record with your current employer?
No, ma'am.
No. Okay.
No, I know it's on my name.
Yeah.
I'm scared to go try.
Right, I understand. I understand. We don't have any other questions, so I think we're ready to vote, Mr. Freeman.
Well, Mr. Bonovich, it hadn't been 10 years, but it's the only arrest on your record. You got let off probation early, only after 2 years of a 5-year probation. My vote today is going to be to pardon with restoration of firearms.
Mr. Tillis?
I concur with Mr. Freeman.
Mrs. Stapleton? I concur with Mr. Freeman. Mr. Craig?
I concur with Mr. Freeman.
As do I. So on your behalf, sir, we're going to make the recommendation to the governor of pardon with restoration of firearms.
Thank you.
Yes, sir.
Well, what a lucky guy. So he's going to get off, that's going to get it removed, and he's going to get his weapons back. Wow. Lucky guy he is today. I bet he's just having a party now. He's going to go get his weapons and go everywhere in the woods towards animals. I feel a little better since I took a shower and did a breathing treatment. My lungs have always been clear. It's just my nose. Y'all, I don't know what else to do. I don't even know if anyone's really here. I just think maybe I should just log off, sign off, and just come back when there's a verdict. Like I said, I have therapy, so I might have to I might not be able to, if they come back with one, I might not be able to do the verdict. I'm sorry. That's what I'm worried about. The seal is still up. I'm watching it on my big 60-inch TV. It's still there. So no verdict yet. These pardon things take forever. I think the next one is Michelle Kane. I just don't know what else to do.
You just give me your name again. I know just give me your name again.
We're going to watch something on the hurricane. So this has been 4 minutes ago.
Tropical storm Melissa is crawling in the Caribbean. Here's why that could be a very bad thing for Jamaica.
Melissa is moving about 2 miles per hour, which is about the pace I'm walking right now, which is fine for a leisurely stroll, but for a storm and its impacts could be catastrophic. Melissa is moving over the warmest waters in the Atlantic, and it's predicted to spend the next few days soaking up all that energy while it passes very close to Jamaica. The result? Forecasts call for Melissa to strengthen to even Category 4 or 5.
I just want to give shout out to CNN News. I will put their link in the description.
Status. That means a storm with 150 mile per hour winds right on the doorstep of Jamaica. But as bad as that could be, Melissa's snail-like pace combined with the tall mountains of Jamaica will allow rainfall to pile up to epic proportions, measured in feet, not inches, and likely to cause devastating mudslides. Slow-moving storms dumping astronomical amounts of rain are consequences of a warming ocean and planet. It's something we have seen more of in recent years. Think Hurricane Harvey in Texas or Hurricane Dorian in the Bahamas.
We do have landfall. Jared just said, you guys can confirm that? I assume we have landfall, according to Jared Maloney behind the camera right now, who just shouted that out. By the way, our team is inside of a very well built structure here in St. Anne Parish, tucked into a garage. We have been showing that earlier today, and we'll try to show that again as situation deteriorates. But what I was saying earlier, gentlemen, is, okay, we are about 50 miles to the east of Montego Bay, and where all those resorts are, so many people. And we got official word, actually, from the tourism minister and his people that there are 25,000 visitors in Jamaica right now. That's a lot of people that couldn't get out of the airports before all of this started to happen this weekend. And so they're very concerned, and they're telling us that they are making sure that the priority is that everyone is safe in those resorts. But certainly with these winds and this activity about to head up into Jamaica and into Montego, there's going to be major issues. Boy, this is a pretty good gust that we got here right now with some blowing, driving rain. As a matter of fact, I think it's blowing into the garage that the team is in right now, unfortunately. And so we are expecting mass power outages. We have up to 40% of the island right now with no power and mobile service as far as data, cell phones. Last update 2 hours ago was 25% of comms were already down. So flying debris is going to occur. Roadways that potentially in many areas are impassable because of power poles that fall, or houses or other structures that are ripped apart. And so getting around is going to be difficult. But I can tell you, we're going to feel the impacts of this for hours and hours to come, well into the dark of night. I just hope that we can keep our communications so we can continue to broadcast and hit the Fox Weather stream and all the Fox Media platforms for all this information. So we've got a degradation already, guys. It's just the beginning. And Jamaica is as prepared as they can be. But what country could be prepared for 185 mile an hour winds and an historic hurricane? Not many. In fact, not any. Not even in the United States.
Robert, you're right. We're confirming it for you. 185 mile per hour winds at landfall, 892 millibar, low pressure. That was near New Hope, Jamaica at 1 p.m. That was our landfall officially made by the National Hurricane Center. New Hope, Jamaica.
New Hope, Jamaica. Mm-hmm. And guys, you know what's so terrifying is the fact that there is a possibility that as it comes up and, wobbles to the east as expected, more toward Montego and where we're at in St. Anne Parish, there is a possibility that when it exits Jamaica, about 65 miles north to south, it's going to be heading south to north, that it's still a Category 5.
Yep.
This system does not cease to surprise. Anything it does, I said it yesterday, I don't trust Hurricane Melissa at all. Any move she makes will not surprise me.
I'm right there with you. I mean, we're looking at, hopefully we're getting a eye wall replacement. That didn't happen. In fact, it looks like the eye, when it was coming on shore, began to shrink just a little bit, probably because of the mountain influence up to the north. But Robert Ray, yeah, your conditions are going to start getting worse and worse every time we check in with you later on this afternoon. So stay dry, my friend, because we will be back with you a little bit later on this hour. Good stuff, Robert.
Yeah, not only has the ERC not taken place, but this thing jogged to the left a little bit, stayed over water longer, super warm water, which has been fueling this.
Right.
And to Robert's point, I mean, you could shave 25 miles per hour off the maximum sustained winds and still be a 5 as this comes off Jamaica.
The amazing part. And the other thing that's amazing, the higher up you go in elevation, the less interaction you have with any kind of friction, the winds pick up in speed.
20-30% easily.
When they make it 240, 250 mile per hour winds on the hilltops.
That's the EF5 equivalents that we've been talking about.
I mean, the strongest tornadoes ever, what, 300 miles per hour?
Yeah.
This is just shy of that, but it's mega. You're talking about 20, 30 miles wide of an EF4, EF5 tornado slam into the west side of Jamaica right now.
So by the numbers here, this is top 3 for pressure.
Right.
That's anywhere in the Atlantic basin at any point in the season.
Including the Gulf, including the North Atlantic and the Caribbean.
Across the period of record. And for landfalling storms, if you go by wind speed instead of minimum central pressure, 185, it's what, Labor Day? 1935.
1935, yeah.
Dorian, and now Melissa.
Meanwhile, we do have some breaking news to share with you at this moment, and that is Hurricane Melissa has now made landfall in Jamaica. This is a live look right here from Montego Bay, and we've been sharing this live look with you for hours, and this is the worst that we've seen so far. Hurricane Melissa, a Category 5 hurricane. You can see the rain, you can see the wind whipping through these palm trees, and over the next number of hours, we are expecting to see these conditions continue to deteriorate. So we did want to share this live look with you. We've been seeing some of these live looks go down, as you can imagine, with the wind gusts as powerful as they are. Electricity and those power outages are a concern. And take a look at this roof right here. You can see that just the top of that roof, really a shaking in the wind as the wind gusts continuing to pick up there. But we did want to share with you, Hurricane Melissa has now officially made landfall in Jamaica. And I did want to share this social media post from the National Hurricane Center with you, stating that Melissa has made landfall in southwestern Jamaica near New Hope as a powerful Category 5 hurricane. We also have a number of other live looks that we do want to share with you. Taking a look, these are 5 different live looks courtesy of See Jamaica, giving you just different perspectives as Hurricane Melissa has now made landfall in Jamaica. And earlier we had 6 cameras. One of them seems to have come down because of those very powerful winds. So we did want to share this with you as we continue to monitor this live look right here, courtesy of See Jamaica. So the conditions continuing to deteriorate.
Please, if you are a prayer or a thinker, thoughter, please keep Jamaica in your thoughts. It's gonna get bad. That is moving so slow, and the warmth of the water is just bad. It's because it's so warm.
Continuing to be a major concern.
Oh yeah, by the way, shout out to Fox Weather
with Mike's weather page in just a moment, but we did want to share this with you as we step away for a brief break.
You're looking live now at Kingston Harbor as Melissa makes landfall in Jamaica. The United Nations, you heard Jeff say it, calling this the storm of the century.
The crews are preparing for a serious humanitarian crisis caused by what's already a deadly storm. We've got live team coverage on this historic hurricane. Michelle Charlesworth has the stories of Americans trapped in America.
But first, ABC's Ike Ajachi live in Kingston, Jamaica as Melissa makes landfall. Ike?
Hurricane Melissa continues to pound Jamaica as right now landfall is imminent, and we're seeing catastrophic conditions really consume this entire island with winds up to 185 miles per hour, and these winds are doing significant damage. Take a look right here. You can see these palm trees swaying in the air, knocking their branches on the ground, essentially littering the roads all throughout Kingston.
All right, y'all. I think I'm gonna shut it down and come back when there's a verdict. I don't know what else. I don't want to watch too much stuff because I'm afraid I might get, someone might strike me or something. So I worry about that. So shout out to Fox News. I think I put everybody in the description. So, all right, y'all, if I don't talk to you today, I will be back the moment the verdict is read. If I'm not at therapy, I apologize if I'm going to miss it. I really do. But y'all have a wonderful day. Stay safe. And don't forget to like, share, and comment. Okay. All right. Thank you, everybody. Bye-bye.